Good morning, colleagues and everybody. The time now is 10 o'clock. We're just going to be waiting for a few minutes to get our
colleagues
quorum
and
going.
everybody.
The time now is 10 o'clock.
Recording
We're
in
just going to
progress.
be waiting for a
Good
few
morning,
minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording
We're
in
just going to be
progress.
waiting for a
Good
few
morning,
minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording
We're
in
just going to be
progress.
waiting for a
Good
few
morning,
minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording
We're
in
just going to be
progress.
waiting for a
Good
few
morning,
minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording
We're
in
just going to be
progress.
waiting for a
Good
few
morning,
minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording
We're
in
just going to be
progress.
waiting for a few
Good morning,
minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording
We're
in
just going to be
progress.
waiting for a few minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording in
We're just going to be
progress.
waiting for a few minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording in
Just going to be
progress.
waiting for a few minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording in
Just going to be
progress.
waiting for a few minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock.
Recording in
Just going to be
progress.
waiting for a few minutes to get our
Recording
quorum
stopped.
going. Everybody.
Thank
The
you.
time now is 10 o'clock. As we are about to wrap it up, just want to indicate quickly if Thembi Nkosi, you've got any apologies before I make the further remarks.
Good morning, Chair, and good morning to members. Chair, I don't have any apologies. Thank you very much.
Mr. Ngoma?
Chair, good morning. I hope you can hear me.
I can't hear you. There's an audio on your side. I can see you. I can see your lips are moving, trying to smile, but we can't hear you.
Chairperson, can you hear me now?
Just fix that. We can't hear you. There's an audio problem that we're not able to hear. I don't know what the problem is.
Chair.
Actually, the problem is with the chair.
Whilst Mr. Ngoma is sorting that out, I'll come back to that. But he's indicating on the chat that we have no apologies.
No,
and
the chair
therefore, colleagues, our agenda has got three items.
Chairperson.
Maybe before I proceed, Honorable Dana, your hand is up.
Good morning, Chair. Now, I just want to indicate that I can hear Thembi Nkosi. Maybe the audio problem is on your side, Chair.
Okay. I can't hear Honorable Dana, so we might have a problem of audio. It seems that it's not only Thembi Nkosi. I don't know whether it's on my side or it's on, is it on my side? Okay, I'll have to check that. Thank you. Can you hear me now?
Chairperson, I can hear you. Can you hear me?
Okay, so I would have, in my last meeting, muted myself from a long meeting. So now I understand why. My apologies. Let me start again, but it's very clear that none of you would have heard what I've said. I have welcomed everybody in this meeting, the honorable members, all of us on the virtual platform, the evidence leaders, the members of the media, our entire support staff, as well as the members of the public joining us as usual in this long journey of this important work of this parliamentary inquiry. I just indicated that Thembi Nkosi to indicate if we've got any apologies. He has already indicated on the chart that we have no apologies. We have 3 items for today's meeting, and the main business of today's meeting being the consideration and adoption of this draft report. And I'll speak to that later. But that main item is flanked by 2 other items We'll start with the issue of correspondence. And under correspondence, there are mainly 3 letters that would have been sent to members that the chair has already responded to. A letter from Chani attorneys withdrawing their services, and we have noted it as such and indicated to them that once their draft report is adopted, it will be sent directly to the public protector. The second letter or correspondence comes from a Mr. Erasmus asking the chair to consider the recusal application and his decision, and also responded to that and indicating that we have no intentions, especially from myself as a chair, that I have no intentions to revisit that decision, and that his letter will be brought to the committee for members' consideration. The third correspondence relates to a letter a few days after the Chani letter from the PP, indicating that she has no legal reps. I would have responded fully, and that letter has been sent to all members. So I'm going to ask Thembinkosi perhaps to attend to that item. After that item, we'll get straight into our draft report, and we'll conclude our meeting by adopting all the outstanding minutes of our work. Mr. Ngoma?
Thank you, Chair. Good morning to you and good morning to members. Chair, you've summed up correspondence very well. I'm not sure if maybe there's something that Ms. Ibrahim would like to add, as he had already indicated that all the correspondence was shared with the members. Thank you, Chair.
Thank you. Ms. Ibrahim?
Thank you and good morning to yourself, Chair, and everybody else on the platform. Chair, in terms of the letter from Chan attorneys withdrawing, that letter, members will see, is quite long and deals with several issues. There was no response directly from the chairperson to that letter, because that letter was, the purpose of which was to inform us that Chan attorneys was withdrawing, and so it was dealt with at the level of the Secretariat. However, as you indicated, subsequently the PP did send a follow-up letter a few days later, indicating that she now finds herself in the position without legal representation, and obviously that this matter must now serve before the committee for consideration as to whether the committee intends to proceed with the adoption of the draft report, or to allow the PP the time to now secure new attorneys, because in terms of the letter that she sent, that is her indication. She has already touched base with Mr. Chawi of the State Attorney Pretoria to secure herself new attorneys of record. And members would have noted from the report itself, we made mention of the fact that advocates cannot be briefed without attorneys of record doing that briefing. You need to work via them. And so as such, Advocate Mpofu has not, as together with his 2 juniors, have not been briefed since the end of March. And what the PP is now seeking is additional time to allow her to attend to the matter subsequent to the withdrawal of Chan. In terms of the letter that was sent by the chair reiterates his position that the committee has not denied Advocate Mqwebani the right to legal representation. Rather, it is a case of her not having availed that right, notwithstanding that the extra 4 million was made available to her, and the chair has encouraged that she uses the services of the state attorney. Members will recall that she previously objected on the basis of there being what she called a patent conflict of interest, and the letter from the chair urges her to utilize these services to brief Advocate Mpofu to assist her with the last Audi that she will receive, which is to respond to this report. But of course, Chair, we are in the hands of members in terms of how members wish to proceed on that point.
Thank you. Thank you, Ms. Ibrahim and Mr. Ngoma, for your inputs on those three correspondence matters. I now invite members on this item who wish to make contributions and comment so that we know what it is the thinking and the decision of the committee and the members. You would have been made aware of what the responses of the chair has been in all of those three correspondence. I now invite members who wants to make a contribution. Honorable Lotrit.
Good morning, Chair, and good morning to everyone present. Chairperson, I think we have now gone through a process, as you said, for more than a year. And we have given ample opportunity. We have gone beyond any reasonable opportunity to allow the public protector to obtain legal representation. And we have been very, very patient. And I think at this particular point, and I also have to say that, yes, one can be very disappointed in the actions of some, I won't know, let me rather not go there, but basically to say, Chairperson, I think at this point, this committee must now proceed with the task that we were given, and that is to finalize this report. I don't think we can delay anymore. We have a duty towards the public, the taxpayer, to Parliament. So my proposal will be that we proceed. Thank you.
Thank you, Honorable Lotrit. Honorable Dlagude.
Thank you very much, Honorable Chairperson. Good morning to you, my colleagues, and everyone on the platform. Honorable Chair, I fully agree with my colleague, Honorable Lotrit, with regard to the committee work. Honorable Chairperson, I don't think it will be difficult for the PP to use the services of the state attorneys to brief the senior counsel, as she still has senior counsel Mpofu as a senior counsel of choice. He was part of the proceedings since the beginning. So this time around is about the issue of the draft report, which we are going to deal with as this committee. Honorable Chairperson, we dealt with this issue. We have come a long way. So for us to be halted at this stage. So I suggest that we proceed with the work of the committee. Then the state attorneys will have to brief the senior counsel of the PP. Thank you very much, Honorable Chair.
Thank you, Honorable Dlagude. As other members are coming, also respond to other letters, including that of Mr. Erasmus, so that it's not taken as if you have not said anything.
Can I come in on that one, Chair?
Can come back. Yes, go ahead.
Thank you very much. I thought we were dealing with this one by one. My apologies. Honorable Chairperson, on that letter of Mr. Erasmus for your recusal as the chairperson of this committee, I just want to say that, Honorable Chair, we started this process last year already, around July. So for that letter to reach this committee at this stage, I don't think it's acceptable. If there was an issue with the chairperson of the committee, that letter should have, with the contents that it has, should have come before this committee at the start of the process. So right now, Honorable Chairperson, the issues that Mr. Erasmus is raising are not issues that, as this committee, would want to deal with. we are not dealing with those issues. Our mandate as this committee was to embark on an inquiry, of which is what we've been doing since the start of the inquiry. Honorable Chairperson, I submit. Thanks.
Thank you, Honorable Lagode, for your second bite. I now recognize Honorable Mautwe. Honorable Ompile Mautwe, you are recognized.
Thank you, Chair, and greetings. I'm battling with Chair. I don't know how else to say this without sounding like, the rhetoric. But to this day, the PP does not have legal representation. And it's not something of your own making. Let's just remind each other that this was as a result of the withdrawal of funding from the office of the acting PP, which has now resulted into the situation we find ourselves in. Now, I've seen the correspondence between you and her and the legal representative, state attorneys, but the essence of it is that she does not have a legal rep. And to ignore that fact, just because we want to rush the process and finalize it, it's unfair. Like, it's not even, it doesn't need a brainer to know that that's unfair. She has explained several times. Firstly, she said she's not comfortable with the state attorneys representing her for reasons that she outlined that I'm not going to repeat. Secondly, they are not the legal rep of her choice. So we can't force them on her, despite the fact that she has even raised concerns of conflict of interest. So I don't know why we would want honesty to rush, analyze this process without her being afforded the opportunity to get the legal reps, and we have a fair process in front of us. I'm appealing to the committee members to say, let's relook at this. We might not like her, but she's in that office. And we are here representing South Africans, all of us. In the spirit of fairness, let's afford her the opportunity to have legal reps. We'll still conclude the process. I don't think there's anyone here who would want, I mean, we've been here for more than a year now, all of us. We're actually tired of this process. But as tiring as it is, it can now be a process that at the end of the day, it doesn't pass the test of fairness. Because as it is now, it's not fair on her part. It's like it's a witch hunt on her, that despite her voices expressing how this is so unfair in the fact that there is a conflict of interest. One. Two, it's not her attorneys of preference. So why are we forcing them? And they came out as well, the state attorney. Now they withdrew. So, Chair, we are back to square one, where the PP does not have a public legal representation. Let's bear with her. Let's find her one. Let's finish this process. It's been unfair from the beginning, I must say. It's not that only now that it's going to be unfair. It's been very unfair. I mean, you've had a lot of applications for your own recusal, Chair, unfairness related to the legal team and all those things. But we are saying we are almost at the end of the process now. Let's just present a fair closure to this matter. That will be my input on that subject, Chair. Thank you.
Thank you, Honorable Mautwe. Honorable Suela.
Thank you, Chairperson. Greetings to honorable members. Chair, let me join other colleagues on this matter. I think we've got 3 issues before us. The first one is the one which is dealing with you. We are saying, Chair, We are not evenly interested to entertain Erasmus' letter because it is not evenly related to our task. It deals with issues of 2019, which is not relevant to this task. Secondly, so you are not going anywhere. We are proceeding with you as the chair. We are in support of what you have alluded, that you are not leaving the committee. And you are not the only decision maker as a chairperson. You are just chairing the meeting. So we are saying we're not entertaining that particular letter. Secondly, on the issue of legal representatives, I think state attorneys are there. The issue of fair and unfairness, I think we've been patient enough. I want to agree with the first speaker that we've been patient. At the same time, we must look both sides of the coin. The issue of taxpayers' money and also the issue of the PP needs to be treated equally. We are in agreement that she must have legal representative, but on the issue of the draft report itself, I don't think that there is any problem, because we are going to make sure that the report is being tabled, and the legal representatives, which at this stage will be the state attorneys, will brief the CC. And my understanding is that the CC, Advocate Mpofu, who have been with him throughout the process, is familiar with all the issues. So I don't see any problem there. We must just continue with the draft report because we want to conclude this matter. Otherwise, we are highly abusing taxpayers' money in this regard. So, to my honorable members, that let's conclude the process and let allow our public protector to respond, because she will be given an opportunity to respond. For now, we're not judging anyone. There is no one who's guilty here, but let's allow the process to unfold so that we exercise or execute our task as per the mandate by the National Assembly. That's my submission, Chairperson. Thank you.
Thank you, Honorable Siwela. I now recognize Honorable Maneli. Honorable Maneli. Boise Maneli.
Yes, Chair. I take it that I'm audible now. Thank you,
Yes,
Chair, and greetings to honorable members on the platform. Honorable Chair, with regard to the three letters, I think there's been a commentary already, because at the time I was raising.
You are muted again. Honorable Maneli, you've muted yourself. You're saying the time you were raising your hand.
The gadget itself. Sorry, Chair. I'm just saying, Chair, my point really at the time was to really note the three letters that have been presented to the committee. And also noting that as the chairperson, you've responded in as far as you can to those letters, and to support that there's been response to the letters. Of course, with the letter that regards the recusal, I think that matter has now been covered by Honorable Dlagude, except, Chair, to make the point that when one looked at the letter, that's why we're not commenting properly, was because we have already made a call, Chair, that matters that seek to distract the committee from doing what it's supposed to do would not entertain going forward. But I took it, Chair, that you wanted to be transparent, that was received and that was responded to. because from where we are, really, they have nothing to do with the matter at hand before this committee. I think Honorable Dlakude explained even the timing of it, as information raised seems to be something else, not what we are dealing with as the committee. With regard to the withdrawal, Chair, again, there I think it's a matter like the legal services would have explained, that it has been responded to administratively. But I think for me, of concern, Chair, which I want to register, because this then borders on what we are now told as unfairness. First and foremost, Chair, the attorney that is withdrawing is not an imposed attorney. It's an attorney of choice of the public protector. And this is the same attorneys, Chair, that were on a deathbed. This is what was presented to this committee, to South Africans. Miraculously, this attorney also rose back again from the deathbed and was ready to move in because he's alive and kicking. So it's important to make this point, because there's not been even the state law advisors coming in this case, because that was clear, and that was at the time of a deathbed situation. Thereafter, as I say, miraculously, it is back to life, live and kicking, ready to take up the task. Again, Chair, from a point of fairness, the same people were appointed because those are the attorneys of choice, not of the committee, not of anybody else. And it is them who are now in withdrawing, having not briefed the senior counsel, which was the main purpose of appointing. But of course, they've done other tasks other than the main task of ensuring that this inquiry is able to proceed with the senior counsel having been briefed properly. So I just thought it's important to make this point because I'm worried, Chair, that probably between the miraculous and the withdrawal, there may have been costs incurred from the same money of the taxpayers that was fought for by this committee outside of what they are supposed to do, but just to make sure that the inquiry proceeds. And that's how that 4 million rand additional came about. So I'm worried that you may not report 4 million in that period of rising from the deathbed, miraculously so, and then you have the withdrawal at the end. So I'm saying it shouldn't be left unattended, Chair, so that South Africans at least know what are we dealing with as this committee in trying to be fair, and that fairness is seen to be practiced from here. So I just thought I must spend time on that part. And I understand the third one, Chair, to be about formally, as the client that elected to have these attorneys, that I'm formally informing you that my attorneys have withdrawn. And therefore, I'm following a process to get attorneys in that regard. And I think the point, the last point to make, Chair, is that then having assessed these letters in the way we've looked at them now, I think, Chair, I want to still agree with the earlier speakers that necessarily the letters have no bearing on the main item of today, because today's report is not about the PP being represented at this point. It is about the committee satisfying itself that its inputs and everything else has been put in the draft report and therefore adopted as its draft report, so that then that report, as again from a principle of fairness again, then that report cannot be a final report until it is also given to the PP as part of Audi, for the PP to also make comments if she elects to do so, which the committee should consider, or elects not to in that way. That will also be a response that the PP would have also been satisfied that the information put in the report is adopted by the committee. There's probably nothing to contest in that regard. So I just thought I should make that point, Chair, so that we do not tap the letters and the main purpose which you've put as the discussion that will ensue in this committee. I thank you, Chair, for now.
Thank you, Honorable Maneli, and I recognize Honorable Sukas.
Good morning, Chair. Good morning to all my colleagues on the platform and everybody listening in. Chair, mine is just to support what has been said by the colleagues in terms of the importance of the committee proceeding with its work. Secondly, the issues around fairness has been traversed extensively throughout this year-long period. And lastly, Chair, to add that the bill that is being footed here is footed by the South African taxpayer. That bill well exceeds 26 million if we add what has been made available now, in addition to ensure that, again, the PP has legal representation in these proceedings. And Chair, we are beyond what is considered reasonable in regard to the constitutional obligation that we have as a committee to, within a reasonable time frame, complete the work that is before us. So I strongly support what has been said. We need to proceed. And also, Chair, to add that this body of Parliament is responsible for oversight over the public protector. Her obligation is to this Parliament. It is for her to appear as a head of a Chapter 9 institution before this body and account. And Chair, it is our job to ensure that it happens. So, Chair, we must proceed. Thank you.
Thank you, Honorable Dana. Honorable Sukas. I now recognize Honorable Ngola.
Good morning, Chair. Good morning to my colleagues. Chair, I must admit that I've struggled to grasp two issues as it relates to Ms. Erasmus's so-called recusal application or reconsideration of a recusal of the chair. The first, Chair, is the relevance, the entire substantive relevance of Mr. Erasmus's letter to the committee, because I think Mr. Erasmus went all over the place and failed to grasp and shoot straight to neither the motion, the report of the independent panel, the court rulings around these reports that are before the table here. So I've struggled to actually get the actual substantive submission in relation to the charges, the motion, and everything else that's related to the work of this committee. Chair, I really don't understand how an organizing committee meeting of the ANC, legal and monitoring, the ATM issues are actually relevant to the context at which this committee was formed. But I saw one attempt to get closer to the CR17 report, but he even fails to go further because Mr. Erasmus speaks about the CR17 report of the PP, but fails to say what the court said about the report itself. That even the applicable laws in that report were just misconceived. The issue of POCA and PRICA, the code of ethical conduct was misconceived. which I think, Chair, from where I'm seated, the letter by Mr. Erasmus is too much far from the work of the committee. They are not related. Maybe we would have, in a different platform, attended to the sentiments shared by the letter. But in this platform, they really do not share a link of the work of this committee. So, Chair, I think the committee must uphold your decision to refuse to recuse yourself on the basis of what was said in the letter of Mr. Erasmus. To Chair, I'm not quite sure what then becomes his locus standi in the proceedings of the committee. I'm not quite sure, Chair, because we want to be fair. So we would allow all the more than 56 million citizens of the country to write to the committee. But I think, Chair, because we have done it before, we have allowed a group of advocates to barge in a committee meeting, and we allowed them to address us because we would actually not want to be far from society as we continue doing this work on their behalf. So I think that's actually the spirit at which we are entertaining Mr. Erasmus. Otherwise, from where I'm sitting, Mr. Erasmus does not even have a local stand to be sending us recusal applications as this committee. Nevertheless, Chair, for fairness purposes, would have entertained the contents of his letter. But I think, Chair, we must not even go deeper because it is just he's discussing apples who are busy with bananas in the committee. So I think let's just be sharp on the issue of relevance of the issues submitted by Mr. Erasmus. Chair, I think on the issue of the withdrawal of the legal representatives, Chair, I wish to plead with this committee that we must not allow any one of us to use the decision of the Constitutional Court on legal representation of the PP as a weapon of mass destruction. At no point did this committee refuse to allow the PP to be legally represented in this committee. But I think it has been an issue that has been used as a missile to take the committee from pillar to post for whatever reason that has no interest of fairness, that has no interest of justice being served, that has no interest of adherence to the rules that this must be done within a reasonable time period. So we have done everything in our power, Chair, even halted the proceedings and went and acted ultra vires because we assisted issues of legal representation that were not part of our own role, because the committee must be seen and must be known as the most fair committee that must allow the PP to have her own representatives in the proceedings. But it does look there, though, that the legal representative matter becomes now a missile or a weapon of mass destruction. And we must remind committee members that even the issue of the state attorney was requested by the PP. The PP requested that the state attorney must come to the rescue because of the challenges of legal representation. And later, that submission was changed by the same PP. It must not be seen by members and the public that we imposed the state attorney to the PP. It's not true, Chair. We acted upon the request of the PP that the state attorney must come to the fore. Lastly, Chair, I wish to share the same sentiments that Honorable Maneli shared here. That actually, Chair, the meeting of the 28th of July and the 30th of July was a committee meeting. Today's meeting is a committee meeting to attend to matters relating to a draft report. the draft report that which is going to be shared to the PP for last commentary. That's why the PP then will require her legal representation, not in this meeting. So there is a time period at which the PP will be allowed to analyze and look at everything that is raised in the draft report, and therefore respond accordingly with help from her own legal representatives. So, Chair, I wish to concur with the members that said we must today proceed with the agenda as set. Thank you very much.
Thank you, Honorable Ngola, for your contribution, and I'll recognize Honorable Dana, and to be followed by Honorable Milam as the last speaker.
Thank you, Chair. Good morning to everyone. Chairperson, I think we are now past the point where recusal applications are even relevant. So I don't think it should even be considered. That's my first point. My second point, Chair, and I've said it before, is we've been more than fair during this process toward the public protector. And I mean, I actually agree with Honorable Manele that today's meeting is where we as committee must consider our draft report. So I think we should continue without further ado. I think we've done everything we can to ensure that this process has been fair. So I think we should continue, finish the report and conclude this process without wasting any further time. Thank you, Chair.
Thank you, Honorable Dana. Honorable Milam.
Thank you, Chairperson. Chair, I apologize for the quality of my connection. I'm in a very spotty internet area. Chair, I want to raise a question to Ms. Fatima Ibrahim, and maybe the committee can then give some consideration to it. My question is this: Rule 129A says that the public protector has the right to be heard in her own defense and to be assisted by a legal practitioner or other experts of her choice. That's what the rule says. It does not say she has to be represented by a legal practitioner. It says she has to be assisted. Now, my question is this: would that assistance require that Advocate Mpofu be briefed by an attorney? In other words, because we're not a court of law, do we have to follow the same court processes where an advocate is briefed by an attorney? Thank you, Chair.
Thank you, Honorable Milam. Before I give Ms. Ibrahim to quickly respond to that, and then I do the summary and the ruling on these correspondence matters, is there any other member that I'm missing? None, thank you. Ms. Ibrahim, any quick points from your side in that, or any other issue you want to pick up before I do the summary?
Thank you, Chair. Unfortunately, Chair, in terms of the code of conduct that's applicable to legal practitioners from the Legal Practice Council, regardless of the fact that this isn't a court process, Advocate Mpofu would have to be briefed via attorneys. So he would not be able to accept a brief directly from the PPSA.
Okay, thank you. That's I hope that clarifies it, brief and to the point. Honorable members, Honorable Milam says a thumbs up is okay with the response. Just to conclude this item on the correspondence, having listened to you, just as a summary from the chair and our ruling on this matter, I think maybe just before one does that, it's important that you would have noted, especially in my letter to the PP, I would have indicated that and reminded the public protector that her attorneys of choice, Chane in this case, there would have been a to and fro correspondence between myself and as a chair and the PP and a legal rep, where they indicated, just to remind you, that they wanted to familiarize themselves with what the evidence that we have in the Dropbox and everything else. And they would have indicated a month to do that, which we rejected. There was no basis for them to do that. Those attorneys were onboarding onto this process. So in fact, when at the point of that letter of attorneys withdrawing, it was exactly after that month that they needed to peruse. So after completing that month of perusing, so the next action is to withdraw. I'm hoping that they did peruse and they've familiarized themselves with that. But the next point is not to say we have now familiarized ourselves and now we're ready to brief the senior counsel. So the next point is we're now withdrawing, citing various unsubstantiated issues in that regard. Secondly, the suspended public protector, since our intervention to secure this funding has had time since the month of May up to August to brief the senior counsel. She's not done that. The only time the senior counsel would have been briefed was in relation to the recusal application. So there was no difficulty in briefing. There was always a way to brief, but it depends on what they wanted to brief. So the issue here is not there's an obstacle in briefing the senior counsel. Otherwise, they would not have briefed the senior counsel for the recusal application if there was that difficult. So it's important to contextualize those issues. And so I hear members quite clearly. Firstly, let me deal with the Erasmus reconsideration matter. I think members are very clear that as a committee, you reject that. There's no relevance. Honorable Ngola would have gone into detail in unpacking how that relevance lacks into that and that it belongs to a different platform, not this section 194. And in summary, collectively members are in support of the response of the chair and the indication of not revisiting that response. And so I think we should put that aside and Mr. Erasmus will be informed accordingly about the committee's deliberations and decision on the matter. I think on the issues of both the China and PP, members are of the view that restating what you have said before, that this committee has gone beyond reasonable patience for this process, contrary to what would have been raised before, that we have a predetermined outcome. We have a rush into this process, and that would have been more than fair, beyond being fair, even to a point where we would have paused on the actual mandate of this and tried to assist on other matters to ensure that things get back to this committee. You are of the view that we must proceed and finalize as we get to the next point of the draft report and finalize our draft report, that the suspended public protector must brief her senior counsel of choice in preparation for her final Audi in response to the draft report. I think there's also an issue raised, a very critical matter that says this issue of fairness must also be looked beyond the suspended public protector. It's also about the interest of the public. And so issues of taxpayer footing the bill has been raised around this. And there's been a serious concern raised about the cost that would have been incurred, even with the substantial 4 million that would have been made available. Today's meeting is not looking into that. And so that this withdrawal of the legal attorneys would have no bearing in us considering and adopting our draft report today. The PP has effectively not been denied, and I say so in the letter in response to her. She's not been denied legal representatives. There's a withdrawal, which is not the same as this committee denying her legal representative. And so that must be very clear. And we still urge her to brief her senior counsel, because we have mobilized the resources in the manner we did. The resources are still available to her disposal to do that. I think further, there's a point being made that the Constitutional Court position on legal representative must not be abused, and therefore we must put it into a proper context. So that's really the majority of views that members have raised here. I do note, Honorable Mautwe, on this issue, making the point that the issues that the PP find ourselves in are not of her own making. And so that point has been registered. We're not going to get into details about that and unpack that. But that would be the summary and the ruling on this matter, honorable members, which basically says Mr. Erasmus' reconsideration letter is rejected, that there's no basis, doesn't belong here, it's irrelevant. There's another platform, he needs to look into another address to take his matter. And that on the issues of the legal rep and the withdrawal of that, members have been very clear that the onus is not on the committee. The onus remains with the public protector to ensure that she briefs the senior counsel to be ready to assist her in response to the draft report that we're going to get to next. So I thank you very much, honorable members. We're going to step off that matter now. I now am going to invite, and then we get to the next point, which is our main point of today. The consideration of this draft report by ourselves as the committee. I think it's important to make the point that on the 28th and the 30th of July, we spent about 18 hours. 10 hours on the Friday, the 28th of July, and 8 hours on Sunday, the 30th of July, with members of this committee. This committee, in its own way, designing, creating a proper framework of this draft report. We did that charge by charge. We did that sub-charge by sub-charge, where the committee would have made decisions in its own way on those charges and those sub-charges, and indicated where it is going. And at the end of that 18 hours, we then agreed that we're going to ask the Secretariat or support team to put together the deliberations, the decisions of the committee, having spent those 2 long days on this report, and would have given them a week or so to do that work. I want to upfront appreciate the work of the support team, our legal advisor, Ms. Ibrahim, together with the evidence leaders and all the support staff, for having knuckled down since the 30th of July to sit every day, every night, flowing from the determination of the committee on each of those matters to put a very comprehensive report in parts A and B. At some point, you would get tired in reading, and I have to read this paragraph, paragraph 1029 of the report, which has 244 pages, and then you go to the next with 247. It's a commendable work that has been done, sacrifice commitment and determination. And that work was able to be put together, and you would have received on the 8th of August, Tuesday, both parts A and B of that report, which details the entire journey of the work of this committee from day one, even as we designed our roadmap. This report that has been submitted to you take us through that journey, both the historical and the now, and goes deep into what you would have indicated around all of those charges. And so you would have had some time to go through that and read, because you're not reading something new that you are coming across for the first time. You are reading your own work, your own product, and especially on the 28th and the 30th of July. And so the report is therefore, as we get into the consideration of this draft report with a purpose to adopt it, is taken as read, as would have been submitted to yourselves. We are taking an approach that I'm going to ask Ms. Ibrahim to summarize, to take us through the summary, section by section of that report. Because today we're not going to do what we did on the 28th and the 30th, where it was hard slog on those 2 days, because this is our report. And so she's going to take us through in presenting a summary of that report, section by section. We'll be flexible in a particular section where you want to reappraise yourself, where you want to remind yourself or reassure about certain details. We can quickly go and say this is where it comes from in this detail of this evidence, in case you would have forgotten something. But we have agreed that we're going to tackle it in this way, especially if you are agreeing on that approach. So I now want to invite Ms. Ibrahim to take the members through the summary of our report. Start with part A, and thereafter we'll take a break, go to part B, we'll take a break. We're also going to go to a conclusion and recommendations section. So see it as kind of 3 parts of the summary that we're going to get into. Ms. Ibrahim?
Thank you so much, Chairperson. Chair, I'm not going to switch my video on because I'm going to ask.
That's fine. Go ahead.
Put it up on the screen. I think that's going to be easier. Chairperson, what we've done is that we've divided the draft report into 2 parts, a section A and a section B. Section A deals with the introduction and charges 1 through to 3, whereas part B deals with charge 4, as well as the conclusion that still needs to be inserted and the recommendation to the NA. Starting on section A of the part A part of the report, Chipper, you can just move down. So Chair, I just want to start off by saying that since sending it to members on Tuesday, we've made very minor changes, nothing of substance. It has been tracked, so members may see as we go along that there has been a change. One of the things, for example, that I did afterwards is where we mentioned impeachment, I've changed it to removal, except insofar as it was Advocate Mkhwebane or her legal team that used that terminology. And members may recall quite early on in the process when I'd given one of my briefings, I explained that in South Africa, we don't use the terminology of impeachment. Section 194 doesn't refer to it as that. It talks of removal from office. And so I've made that as that's an example of a change. We've started off with abbreviations, and these are carried through for purposes of both parts of the report, but we can move through that fairly quickly. These terms are also captured in the content itself. So where, for example, we use asset forfeiture unit, we would have said it in full and then in brackets AFU. So it's not necessary that members would have to keep referring back to this table, but it is just there to make things easier for the readers, especially those that wouldn't have been involved in the process. You can move down.
Fatima, for easier reference, I have the headings on the left side of the screen. So you can just tell me where to go if there's a specific area that you want to go to.
Okay, I think we can skip all of these beginning parts. The only other thing is that we've listed the cases referred to, and we've also listed persons whose names appear in the report, and it's not necessarily every person because some people are really just mentioned once, so it wasn't necessary. The only change that I made last night was to add the name of Ms. Zulu Sakoni there, because we have in fact mentioned her on more than one occasion. I think we can then skip to Roman numeral 1, background and overview. Chair, that very briefly was just an introduction to Chapter 9, institutions, the principles that govern these institutions, such as independence, impartiality, non-interference, etc. The fact that this committee is the committee that's envisaged in Section 194, who's charged with determining the veracity of these charges. And members will recall quite early on that Advocate Mpofu argued, I think it might have even been during his opening statements, that this committee was not the committee for purposes of 194, but members did not agree to that. Initiation of inquiry, that's number 2 there, Chipple, Roman numeral 2. That just sketches a background that there was a substantive motion that was ruled in order as per the removal rules, that it was referred to an independent panel, and that panel report served before the NA, and that is how the motion came to be before this committee. The next one, Chair, was scope of inquiry. Chair, this section sets out the fact that the committee has considered all of the charges in the motion, and not only those in respect of which the independent panel had found prima facie evidence of. And we set out why the committee treated it as such. Legal advice was given on this very early on because it was one of the first objections raised by Advocate Mqwebani. So this really just summarizes and captures the previous advice given. Number 4, legal framework of the inquiry and the committee proceedings. There just a very quick summary of the applicable NA rules, the terms of reference that the committee adopted on 22 Feb 2022, which provided for the use of an evidence leader, the fact that the chair has issued directives. We explain why that was necessary. And then, of course, the fact that the Powers and Privileges Act was utilized by the committee from time to time, to the extent that people had to be summoned and witnesses had to be sworn in. Roman numeral 5, grounds of removal. We take the reader through the fact that there are 3 grounds for removal: misconduct, incapacity, and incompetence. But only one ground needs to be established to justify removal. We record the definitions of misconduct and incompetence as per the rules, because of course incapacity isn't one of the charges. And we capture the fact that the Constitution requires a lower standard for a Chapter 9 office bearer's removal than it does in respect of a judge. But the threshold of removal has been regarded as high by the committee, given the constitutionally entrenched independence that these institutions enjoy, and that the findings have not been arrived at lightly. We explain that these definitions of misconduct and incompetence have to be understood within the context of what is expected from a PP, and to that extent, we refer to Section 182 of the Constitution, as well as the testimony of both Mr. Ibrahim and Ms. Zulu Sakoni, who were the 2 expert witnesses and who set out the standards of conduct. And Ms. Sakoni, of course, also dealt to some extent with the protections that should be afforded to the public protector. So that is all captured in that section. Roman numeral 6, approach to evidence. We indicate there that the committee is not a court of law and it was not required to reconduct the investigations. So in other words, it was not the duty of this committee, for example, to make a determination of whether the SARS unit was rogue as alleged, or whether the FLIEDA beneficiaries, let me not even go there. I think the example that I've given is sufficient, that the committee was not tasked with reinvestigating what the PP has investigated, but rather to capture whether in her investigations she's done what is expected of her in terms of the standards of conduct that she ought to follow. Number 7, the evidentiary value of court judgments. Members would have noted that before the IP, the public protector had raised the Hollington rule, which is an English rule in terms whereof evidence from a criminal trial would not be allowed to be used or is not admissible in a subsequent civil proceedings. And that was raised in evidence with Mr. Pillay, as I recall, and Advocate Mpofu also, when he did his opening statements, also spoke to some extent about the role of these judgments. There being general agreement that the motion was rooted in various adverse judgments and what the committee was going to do with those judgments and how we would treat it. And we've made it clear that the committee didn't just blindly follow judgments. The committee, in fact, sourced additional evidence that would not have been before the courts. It's given Advocate Mqwebane the opportunity to respond as to why the courts may have been wrong. And in so doing, we arrive at independent conclusions. But equally, as Advocate Mpofu had also pointed out, that's not to say that those judgments could simply be ignored, because of course they couldn't. Then Roman numeral 8, we note that it's not a comparative exercise, notwithstanding that comparisons were drawn with the previous public protector. This motion was restricted to Advocate Mqwebane, and it's her conduct that must be assessed by the committee, not the conduct of any of her predecessors. Public participation. Chair, we just did a summary there of the process that was followed by the committee, the number of submissions received, the fact that when those submissions were received, we checked whether they speak to the charges in the motion. Many of them were simply complaints that the public had against the PPSA regarding the way in which various investigations have been conducted. And then, of course, other people that also expressed support for the PP. And we summarize which witnesses there were called by the evidence leaders pursuant to that process. Then Roman numeral 10, the hearings, we record when the hearing started. We list every single witness there and who called that witness, whether they were called by the evidence leaders or whether they were called by Advocate Mqwebane. Section B of the report, Chepo, the preliminary and interlocutory issues.
Yes, just pause there. Maybe before you proceed, just want to check with yourself and the members. So you can indicate, Fatima, what as we go through this report, whether you want us to wait until you finish or you're comfortable in doing it bits by bits. That's one thing, so that you can indicate, but also to ask members whether you're comfortable so far with the approach. I want us to be a bit flexible so that where members want to come in, they will be able to either speak or raise their hand on the issue. So let me just settle that so that we have a smooth run of how we go through this. I'll start with you, Ms. Ibrahim.
So, Chairperson, the content advisors are sitting with copies of the report, and they are going to be making detailed notes of anything that members want us to change. So certainly it's better that we deal with it then part by part. And if there is a particular paragraph that members have spotted an error in, or they want us to redo the wording, to please just indicate so that they can capture it as we go along. Otherwise, I think it's going to be too much to leave to the end. So perhaps now that we've concluded with part A, which is the background on that you ask if members wish to make any further comments there.
Yeah, that helps. Thank you for that. And then for the next parts, you will pause when you know that you've completed this part, and then so that I can go back to the members. Thank you for that. Honorable Nkosi.
Thank you, Chair. This is myself. I'm not an artificial thing. Thanks.
We see you. We see you. We are born. Go ahead.
Chair, no, on paragraph 6, I think it should reflect in the final report, it should reflect the third application for reconsideration of your recusal. Thanks. That's all, Chair.
Thank you. Did you get that, Ms. Ibrahim?
Yes, Chair, but it is dealt with later on in the report, in the next part.
Okay. Thank you. Any other members on a brief comment so far? Are we happy? I get it. That's an indication. Thank you, Honorable Nkosi. Please proceed, Ms. Ibrahim.
Thank you, Chair. Part B, the preliminary and interlocutory issues. Chair, members would know that there were many of these issues that we've been seized with since proceedings started. What we did, however, was to concentrate on the ones that the PP has raised in her statement, rather than capture absolutely everything that has happened since the beginning, every objection and so on, because there has been many. We do make it clear, though, and we emphasize the importance of correspondence, and also to listen to the input of the PP and her legal team when some of these things were considered. So the first one was that it was a politically and racially motivated campaign. And Chair, here we've simply said that the fact of the matter is that there are serious allegations against Advocate Mkhwebane, and the committee has conducted at length a fact-seeking exercise, at the core of which is accountability. But we do, however, note that there were parties that objected through the proceedings on the basis that they thought that it was not fair, and they raised concerns. And we name some of the, or list rather, some of the delays that the committees faced, and why we faced those delays. And we make it clear that it's not the case that the committee lays the cause of every delay at the door of the PP. There were, of course, other delays, whether it be with witnesses or whatever the case may have been, for which nobody's at fault, illness being another example. But the ones that she's raised specifically, we've tried to deal with specifically. Sorry, Chair, I skipped ahead, but you can move to political and a racially motivated campaign. And I took the committee through this when the committee deliberated, Chair, so I'm not going to go through it again, other than what I've said, is to say that the allegations were serious, and the committee had a motion before it, which it had to consider. Then the next part, Chair, proceeding in the absence of legal representatives. Advocate Mkhwebane raised this in her statement to the committee, and we've dealt with various incidences. We've dealt with, firstly, and we did it in chronological order, Chair, 13th to 16th of September when she was ill, and we set out what happened there. And Chair, much of this would have been traversed and covered in some detail in correspondence where we've provided reasons and so on. So these are very short summaries, really. The report would have been hundreds of pages if we had to go into the detail of what was contained in that correspondence. We then also dealt with the so-called walkout, the presentations of evidence leaders. Members will recall that after the withdrawing of funding, evidence leaders then gave presentations to the committee to assist it on CR17 SARS. And Advocate Mkhwebane had objected at the time that we were continuing in the absence of her legal representation. And then we've dealt at length with what's happened beyond March 2023, because of course the last hearing of the committee was at the end of March. But what I would need to do here, Chair, is to just add 2 or 3 lines on the decision that the committee's taken today. I think I did insert the withdrawal of Chan attorneys, but of course I was not able to insert what the view of the committee was on that. But we will insert that in 2 or 3 lines. Then there was the recusal and removal applications. And we list the Chair, that's also done in chronological order, the first recusal application against yourself and Honorable Milam. And we don't go into detail as to why yourself and Mr. Milam declined to recuse themselves, because that is covered already in terms of documents that form part of the record. We deal with the removal application in respect of the evidence leaders, and then the second recusal application in respect of the chairperson. And that is just a summary of these recusal and removal applications thus far. The next section, Chair, deals with the refusal to call the President, Ms. Mazzoni and Minister Gordhan. And we very briefly set out the reasons for same. Again, that was discussed at length in the committee, and the reasons are also set out in full in correspondence that would have been shared with the PP when these decisions were taken. The next one, refusal to recall Ms. Baloy and Mr. Pillay and Mr. van Lochenberg. Again, we set out the reasons there and why the committee hasn't recalled them. The fact that the PP was invited to submit written questions, and that she could have similarly also asked that these people be subpoenaed, considering that they didn't want to come back voluntarily despite us requesting them to do so. Mr. van Lochenberg, for example, sent quite a long letter explaining why he won't subject himself to further cross-examination. So we just detail that in that section. The next one is Advocate Mkhwebane raised that she didn't have sufficient time to prepare her evidence, and that would have been her statements. And we just set out briefly a timeline there, and the fact that extensions were in fact granted for the submission of a statement, and the statement in fact then was submitted in 2 parts because the chair had afforded additional time. The next section deals with previous attempts to remove Advocate Mkhwebane, and this in her statement refers to attempts that were made by the DA when they filed previous motions, and also attempts by the DA within the Justice Committee. Chair, here we just simply indicate that this committee is hearing this motion for the first time. This committee has never been seized with a removal application or a removal motion in terms of the public protector, but in any event, nothing would prevent any member from Parliament from submitting multiple motions. And in fact, the public is sometimes confused, thinking that this Section 194 committee is an ad hoc committee. It is in fact not an ad hoc committee. This is a permanent committee of the Assembly. So it is entirely possible that this committee would be seized with 2 motions for a Chapter 9 institution office bearers removal during their term of office. It would not be impossible. In this case, however, of course, we only have this motion that this committee has dealt with. The next one, Chair, is prejudgment by the Justice PC. And Advocate Mkhwebane refers to a meeting of 6th of March 2018, which would have been an oversight meeting of the Justice PC. She refers to statements made by the chairperson. Those were dealt with extensively in the chairperson's response to the first recusal application, so they're not repeated in the report. And what we simply capture here, Chair, is that as part of oversight must be robust. It is expected that members will engage with those organs of state that are accountable to it, to ask tough questions, to criticize where necessary. And it could never be said reasonably that if such a robust exercise were to happen, that a committee would never be able to then remove the office bearer because of what had transpired earlier. Effectively, it would mean that that Parliament wouldn't be able to act, or would have to be very careful in the way in which it does its ordinary oversight, and so that can't be, and that's what we try to set out in that portion of the report. The next was that the removal rules were designed for the PP. Chair, yeah, we've simply stated that the rules have been tested in the Constitutional Court, and the Constitutional Court that found that the rules were in order, except on this issue of legal representation, which of course has been accommodated for. So the rule no longer has that proviso anymore that says that limits the participation of the legal representative. Then there was an issue raised in respect of double jeopardy. And this arose from the fact that the PP is facing criminal charges in relation to a charge of perjury on the Saab lifeboat matter. And the complaint was that Mr. Kikana had given evidence on the same matter. And here we've simply said that from a legal perspective, she's not in jeopardy of conviction of a crime by this committee, because of course this committee does not perform a criminal function. And that, Chair, takes me to the end of those preliminary and interlocutory issues. Thank you.
Thank you. Brian, any comments, members, on that section that we have just concluded? Whilst I'm waiting for hands, can you just go back to paragraph 198, Ms. Mori, which relates to the 6th of March 2018 issue? It's just a slight correction there. It's not changing the context and the substance of this. Just to indicate that because I'm only it's done properly in the first recusal response, because myself as a chair and another member here, Honorable Ngola, in 2018 were not members of that Justice Committee. I was in the legislature. I don't know where he was. I think the matter they were referring to what would have been comments that we made in an oversight annual report in 2019. So it's just to fix that particular date so that it's not confused as if we're members of the NA in 2018, because we're not. We were only immediately after elections that we became part of the Justice Committee. Just that kind of fixing and correction, but it doesn't change what really the paragraph is. Any other member? If none, we will proceed to the next section. Ms. Ibrahim.
Thank you, Chair. The next section is charge 1, and that is the charge of misconduct in respect of the lifeboat report. And so, Chair, what I've done is just to briefly go through each of the charges and remind the committee of its findings. But what I want to just state up front, Chair, is that whilst the committee made findings on certain things, the test was still whether those findings would support a finding of misconduct and or incompetence. In the case of this particular section, we're only dealing with misconduct. So if I were to give an example, if there was a matter in which I, Fatima Ibrahim, is accused of not performing because I failed to deliver a legal opinion within a turnaround time of 7 days in which I was supposed to have done it. And then the committee has now considered that, and the committee finds, indeed, I was meant to do a legal opinion. Indeed, I failed to give that legal opinion within 7 days. So the finding is there that factually that is correct, but the committee then has regard, for example, to the fact that My reason is that I was ill or I was hospitalized, therefore it was not possible. And so the committee finds that I've not committed misconduct. So the fact that the committee has made findings on certain things does not necessarily mean that those findings then translate into misconduct and or incompetence. I just wanted to make that clear. Members must just keep that in mind as we go through the charges. The first one, Chair, is the charge 1.1.1. And this was about secretly meeting with the presidency, and the majority agreed that Advocate Mkhwebane had met with the president to discuss the merits of the investigation, and she failed to file a transcript. And we record the minority view, which would have been, if I recall correctly, the view of Honorable Heron, that the meeting was undisclosed, but it wasn't a secret meeting. The next one was a similar charge. Well, it's part of the same charge, in fact, meeting with the SSA. And again, the majority agreed, and we captured the minority view that it was not a secret meeting. Then 1.1.2 was a charge that Advocate Mkhwebane had materially broadened the scope of the investigation when compared to the provisional report. There, the committee had agreed that the evidence establishes that she had indeed done so. The next one, 1.1.3, was that she had materially altered the remedial action on instruction of either the president and or the SSA without giving notice and an opportunity to comment thereon to affected parties. And the committee there also agreed that the evidence established that. 1.1.4, that Advocate Mkhwebane had failed in her duty to give affected persons, including the speaker and the SARB, notice and an opportunity to comment on her findings and propose remedial action that she intended to take, and that this had severely damaging consequences to the country and the PPSF. And here the committee also agreed with that. The next one, 1.1.5, was that she failed to honor an agreement with the SARB to make her report available 5 days prior to the release thereof. And here the committee agreed that there was no evidence of such an agreement, and therefore she cannot be found to have failed to have honored an agreement. 1.1.6, that Advocate Mkhwebane had failed to refer or even discuss submissions made by the SARB or any other person. And here the committee found that in relation to some evidence for SARB, for example, that even though it was unsatisfactory in the way in which it was dealt with, she did refer to and discuss most of the concerns that the SARB had raised. And similarly too with APSA, however, she failed to deal with or engage with the Minister of Finance's submissions. And the finding then under this section was that Advocate Mkhwebane is guilty of misconduct in that her investigation in the lifeboat matter and the litigation that ensued, she adopted a dismissive, high-handed, biased and procedurally unfair approach in the investigation. So yeah, we would just want members to confirm that they agree that the finding of misconduct is sustained in respect of these findings that I've just referred to. In other words, that members agree that the factual findings also support a finding of misconduct.
Okay. Okay, thank you. Let's pause there. Honorable members, can I hear your voices on this? Your take? I'm inviting hands and comments on what Ms. Ibrahim has drawn us to. Any takers? Do you agree with the issues? Do you have a different view? What is your take, members? So have you been caught unaware? Honorable Lothrit?
Chairperson, just to say that I agree with the report thus far. Thank you.
Thank you, Honorable Lothrit. Honorable Ngosi?
Chairperson, I also agree that factual findings uphold the charge.
Thank you, Honorable Siwela. Last hand.
Thank you. Thank you, Chairperson. I happen to agree with the summary. It's a true reflection of what we deliberated on those previous 2 days. Thank you.
Thank you, Honorable Maneli.
Well, thank you, Honorable Chair. My hand earlier has been about maybe just as a matter of principle, but for those matters that we may not comment on because we agree, like the ones that have already passed, that for purposes of record, at least it gets recorded as such that there's agreement in the committee of those aspects. So that's the first point, maybe before I comment on this one. Secondly, Chair, even where there's been a possible amendment or correction made, that we are also affirming on that, so that when that addition, for example, on the withdrawal application issue, that as it will come in, that at least that has been affirmed by the committee. So I also agree with this one, that yes, the factual is confirming a substantiation of what has been put through. I'm not sure, Chair, if it will be demanding too much, that probably where you have a situation where there's been the independent panel, using this all the time, where there's been at least also independent panel making a finding, and that is substantiated, I think, on record, at least it be also put as such, because there will be instances where the independent panel may have not expressed a view, but from a committee side of things, we have picked up based on evidence put before the committee, that it may not be with regard to independent panel. So on this one, we have an issue from the side of the committee. So that's why I was raising the hand earlier, Chair, before we got to this point. Yes, so I just wanted to raise those for purposes of record. Thank you.
Okay, thank you, Honorable Maneli. That's very helpful to just guide us through the process. No further hand. Is there any dissenting view? None. We'll proceed. Thank you, honorable members. I think your points are taken in terms of just the clinical way of doing this. Back to you, Ms. Ibrahim.
Thank you, Chairperson. Chair, in the first section of the report, we do include all the charges on which the independent panel found that there was misconduct and incompetence. And of course, our report doesn't necessarily mirror exactly what the independent panel found. If we have time in the final report, because it won't make a difference to the content of the draft report for purposes of giving the public protector Audi, we could try to put in footnotes to say, in this particular case, the IP found differently, if that would help. Chairperson, moving on to 1.2 in the motion, and we're still on charge 1 of misconduct in the SARB matter that dealt with specifically the litigation. And there the committee found that indeed the public protector failed to give a full, frank and honest account of her meetings with the president and the SSA, and that she misrepresented her reliance on economic experts like Dr. Makoka, Mr. Goodson, as well as Dr. Moodley. And so the committee found that those facts were all established. And the finding there, Chair, is that the committee finds that she has committed misconduct in that she failed to meet the essential standards of honesty, transparency, fairness, and independence, and was not rational, as alleged in charge 1. And if everybody's happy with that, I can move on. In fact, Chair, I think for the next section,
Just pause. Let me check with members so that I think, as Honorable Maneli was indicating, we do that. Honorable Ngosi.
Agree with the summary, Chair. The committee agrees.
Thank you. That's Honorable Ngosi. Any other member?
Honorable Maneli agrees with the summary.
Thank you, Honorable Maneli. Honorable Lagode.
Agree, Honorable Chair.
Yes, Honorable Lottridge.
Agree, Chair.
Thank you. Honorable Ngola.
Agreed, Chair.
Thank you, Honorable Ngola. Do we have any dissenting view? None. Thank you. We proceed.
Thank you. Chair, I'm moving to charge 2, which is misconduct in the Vrede Dairy matter. And that starts at paragraph 4 of the motion. In terms of 4.1, the charge was that Advocate Mkhwebane narrowed the scope as required by the complaints. Members will recall that there were the three complaints and as commenced by her predecessor. And here the committee found that the evidence establishes that she did indeed narrow the complaint by failing to consider various significant issues, which included value for money, the Gupta leaks, beneficiary matters, non-compliance with environmental legislation, and so on. And the report goes into detail on each of those. And there are some things where the committee didn't make a finding. So, for example, on the issue of cattle deaths, where the committee accepted the explanation. So a thorough reading of the report will show exactly which elements of the charge the committee agreed to and they didn't, as per the deliberations that took place. Paragraph 4.2 was an allegation that Advocate Mkhwebane had failed to investigate Dr. Yankelsen's third complaint. And there the committee found that the evidence established that she failed to investigate and report on material components of that third complaint without providing a rational or proper explanation. And that her claim that the third complaint was addressed in her response to the first 2 complaints is unsustainable because most of the issues raised in the third complaint are not addressed at all in the Vrede report. And we also refer to the fact that much of that was then carried through to that second Vrede investigation and the second Vrede report, which does not form part of the subject matter of this motion. Paragraph 4.3, that was a charge that the investigation steps were wholly inadequate given the magnitude and importance of the complaints, and that there was no rational or proper explanation provided for the failure. And here the committee agreed that the issues in the investigation were of great importance because they involved vulnerable members of the local community, as well as allegations about the improper use of hundreds of millions of rands in public funds. We found that the allegation that she removed a provincial investigation from the provincial investigator, that would have been Ms. Lears, from the Vrede matter because of her perceived political affiliation, that was unsubstantiated. We found further that the facts as a whole established that she acted irrationally in failing to interview various persons, including senior officials, senior politicians, representatives of Estina, that she acted irrationally in failing to call for to subpoena critical documents, including financial records, agreements in respect of the beneficiaries, updated beneficiary lists, and so on. Then in 4.4, the charge there was that Advocate Mkhwebane materially altered the remedial action in Advocate Madonsela's provisional report, and it was common cause that there was in fact no provisional report by Advocate Madonsela, and therefore that charge was unsubstantiated. 4.5, that she gave contradictory explanations for her conduct to the High Court under oath, and the facts established that indeed that was so, and the report sets out the different explanations that she had given as to why she didn't report various things. And the conclusion there, Chepo, if you just go down, it should be in bold. Yeah, you can go further down. Yeah, there we go, 829. The conclusion is that the committee satisfied that she's committed misconduct in relation to the theatre report, the manner in which it was investigated, and the subsequent litigation. So if we can please just get input on that finding in bold there, please, Chair.
Yes, thank you. Honorable members, I invite you on 829, your comments on that finding by the committee. Honorable Ngosi.
Chair, I agree with 829, paragraph 829 of the committee.
Thank you.
Of the report.
Thank you, Honorable Ngosi. Honorable Lagude.
Honorable Chair, is the true reflection of the committee's finding. Thanks.
Thank you, Honorable Lagude. Honorable Lottridge.
Chairperson, I agree with it.
Thank you, Honorable Siwela.
I agree with the report, Chair. It's a true reflection.
Thank you, Honorable Mola.
Ngalo yonakasana.
Ngosi, Honorable Mola. Honorable Sukas.
Thank you, Chairperson. I agree with the report. Thank you, Chair.
Thank you. Is there any dissenting view? None. We'll proceed. Over to you, Ms. Ibrahim.
Thank you, Chair. I'm moving on to charge 3, which is incompetence, and that's the last charge that's dealt with in this section of the report. And for this charge, Chair, reliance was placed on all of the evidence in relation to charge 1 and 2, so CX as well as Friede, and then there was an addition of the Chidi matter as well. So incompetence in respect of the SARB 7.1.1, the charge was that Advocate Nkwebani had grossly overreached and exceeded bounds of her authority and had unlawfully trenched on Parliament's authority and the National Executive to determine socio-economic policy, and that had to do with the amendment to the Constitution. Chair, the committee had agreed that the facts they had established that it was in fact so. Then in terms of 7.1 to 7.1.6, so that's 1, 2, 3, 4, that's 5 subcharges there, Chair. I had explained when we were deliberating that there are some charges that appear under the misconduct charge that then is also carried across to incompetence on exactly the same facts. And where that is the case, and the committee's already made findings on misconduct, the committee makes no findings on incompetence in respect of those particular charges. So that would be 7.1.2, 1.3, 1.4, 1.5, and 1.6, and we've recorded it as such, Chair. 7.1.7, that was a charge that Advocate Nkwebani had demonstrated irrationality, forensic weakness, incoherence, confusion, and misunderstanding of the applicable contractual, constitutional, and administrative law principles in the SARB matter. And here the committee found that the evidence establishes that she had acted irrationally and or demonstrated a fundamental misunderstanding of applicable legal principles. And we set out the reasons as to why and the different instances in which that occurred. And the committee had found there that there was a serious and worrying understanding of fundamental legal concepts. So Chepo, if you can just go down.
Sure.
No, you're on the wrong section. You should move to No, I think you're right. No, I think you're right. Yeah, you can just move a little bit down.
Okay.
Yeah, you can move more. No, sorry, you can wait. Sorry. 7.1.8, Chair, was a charge that the public protector demonstrated that she does not fully understand her constitutional duty to be impartial and to perform her functions without fear, favor, or prejudice. And there the committee agreed that during the investigation she showed a lack of independence, and that caused intentional or recklessly caused serious economic harm and failure to act fairly in the respect of the SARB, the Minister of Finance, Parliament, ABSA, and other parties with a serious interest in the lifeboat report. But that all of that was captured above in the context of misconduct allegations. Then 7.1.9, the heightened duty towards the court as a public litigant. And this is that the public protector has failed to appreciate that duty. And the evidence there, the committee found, establishes that in numerous instances, Advocate Mqwebani failed to appreciate her duty towards the courts as a public litigant. But these issues have already been dealt with in the committee's findings in respect of misconduct. Therefore, it was not considered again in respect of the incompetence charge under 3. Then 7.2.1, Chair, maybe we can just deal with the SARB before I move on to FLIADA, because from 7.2, that deals with the FLIADA investigation. So if members are satisfied with what we did there, which was not to find a double finding of misconduct and incompetence, because to some extent they're not reconcilable. So where we have found misconduct in the first charge, we then don't repeat that under incompetence to the extent that the charges are repeated or mirrored in that section.
Yeah, very important. Members, 9.903. Let me hear your comments on the issues Ms. Ibrahim is raising. Not to repeat the finding, that it will be suffice to have done it under misconduct. Honorable Nkosi.
Agreed, Chair.
Honorable Nkosi supports and agrees. Honorable Dlagude.
Agreed, Chair.
Thank you. Honorable Mananiso.
Agreed, Chair. Thank you.
Honorable Maneli.
Agreed, Chair. That distinction was canvassed before.
Thank you. Thank you. Honorable Siwela.
Agreed, Chair. Thank you.
Honorable Lotrit.
Agreed, Chair.
Thank you. Honorable Nola.
It's in order, Chair.
In order. Do I have any dissenting view on that matter?
No, we don't, Chair.
I'm asking for a dissenting view. You can't speak for absence. There is none. We proceed. Over to you, Ms. Ibrahim.
Thank you, Chair. Moving on to incompetence. So we're still on charge 3, incompetence, but now in respect of the FLIADA dairy matter, and that falls under paragraph 7.2 onwards of the motion. 7.2.1, that the PP demonstrated a failure to conduct a lawful and meaningful investigation and a failure to grant appropriate remedial action. That's dealt with in full in the report, and members were in agreement in respect of that. The only element where there was no adverse finding there, Chair, is that there was no evidence that her meeting with Mr. Magashule, which was the brief meeting that she had, that Mr. Samuels had taken us through, that there was evidence there to contradict the PP's version that it was merely a meet and greet and that it wasn't an investigative meeting. So apart from that, members were in agreement that she failed to conduct a lawful and meaningful investigation or grant appropriate remedial action as set out in the motion. 7.2.2, failure to appreciate the legal duty to come to the aid of the vulnerable, and that would have been the Vrede beneficiaries, and the committee agreed that the facts established this. 7.2.3, failure to appreciate that her investigation was wholly inadequate and grossly negligent, and or her failure to conduct a lawful and meaningful investigation. Here, the committee had also found that this was established by the facts. 7.2.4, that the PP demonstrated legal ineptitude in her ability to comprehend and accept the inappropriateness of her proposed remedial action in the report. Here, the committee also found that this was established in terms of the facts. Then 7.2.5, that she demonstrated irrationality, forensic weakness, incoherence, confusion, and misunderstanding of constitutional and administrative law principles. Here, the committee also agreed that there were various instances of irrationality and forensic weaknesses. Then 7.2.6, the public protector's duty towards the court as a public litigant. Here, the committee had agreed that the evidence establishes that Advocate Mkhwebane had failed to make the required full disclosure to the courts on matters related to Estina, that she did not disclose that she had declined the opportunity to meet with beneficiaries at the site visit, that she had misled the High Court into thinking Advocate Madonsela had approved a November 2014 draft report and failed to disclose any other draft reports in her Rule 53 record. And she gave a misleading impression that there was nothing implicating Premier Magashule and MEC Zwane at the time, and therefore she misled the High Court. So there, the committee had agreed with all of those findings. And that takes us to the end of Vrede. And the ultimate finding and conclusion there was that incompetence has been established in the Vrede dairy matter, but like SARB, some of it would have fallen under misconduct.
Okay. At that point, I'm back to you, members, to confirm or not. Your take, Honorable Maneli.
That's agreed, Chair. Like I said, that distinction is now understood. Thank you.
Thank you, Honorable Maneli. Honorable Jagode.
Agreed, Chair.
Thank you, Honorable Lotrit.
Agreed, Chair.
Thank you, Honorable Siwela.
Agreed, Chair.
Thank you. Just is that a new hand, Honorable Maneli, or you have gadget problems? Thank you. Any other member? Is there any dissenting views? None. We'll proceed. Thank you. Over to you, Ms. Ibrahim.
Thank you, Chair. Moving to paragraph 7.3 of charge 3. That's a charge of incompetence in the Chidi matter, which is also referred to as the FSCA matter. So, Chair, this is an additional matter that is then introduced for the first time in this charge. And there were two subcharges. 7.3.1 was that the PP in the litigation conceded irrationality and forensic weakness and misunderstanding or misapplication of legal principles. Chair, here the committee had found that the facts do not establish this because it doesn't. The court records before the committee didn't indicate why the PP had conceded the FSCA report. So she didn't make any admissions that the report was irrational or forensically weak or subject to an error of law. She merely did not explain to the court why the report should be set aside. So on 7.3.1, we didn't have facts to arrive at a finding that she had conceded as per the wording in the charge. However, on 7.3.2, which was a charge that she had failed to appreciate her heightened duty towards the court, the chairperson, the facts showed that she had failed to explain to the court and to the other litigants why she believed that report to be invalid. Therefore, she deprived the High Court of the ability to assess whether she had conceded for a good reason and whether its order should have included further directions to avoid a repetition of that error, and whether the punitive cost orders sought by the applicants were warranted. So had she merely taken the court into her confidence and explained why she was not going to challenge that review, there might not have then been those adverse cost orders. So that is on the Chidi FSB at 7.3 of the motion, Chair.
Thank you. Back to you, honorable members. Do I hear you with your contributions and interventions?
Okay, we just move on then, Chair. The conclusion on charge 3 dealing with incompetence. We've indicated that across very important investigations and in numerous rounds of Superior Court litigation, Advocate Mqwebani has demonstrated a repeated and sustained failure to deal with evidence in a rational and appropriate manner, as well as a fundamental inability to engage with critical legal principles or to fashion appropriate remedial action. She's repeatedly neglected her duties as a constitutional office bearer and officer of the court, as an organ of state. She's demonstrated a lack of knowledge and legal skill. And then we speak of the inadequacies in the theatre investigation, the lifeboat investigation, and the harm that was occasioned by those two investigations, and how that may have led a reasonable person in society to question her ability to discharge her duties and functions, and therefore to negatively affect the public's confidence in her. Chair, the repeated failures and the conduct in seeking to defend these failures before the courts show a sustained lack of necessary knowledge and skill, as well as a fundamental inability to discharge the duties of office in an effective and efficient manner, and therefore she's demonstrated incompetence. So here, Chairperson, members will recall that when I did my presentation before the deliberations, I'd indicated that on incompetence, the wording in the removal rules is such that one act of incompetence, or even 2 or 3 acts of incompetence, may not be enough to sustain a finding of incompetence. It would be necessary to establish that incompetence is, in terms of the definitions of the rules, is a knowledge, a demonstrated and sustained lack of knowledge to carry out an ability or skill to perform his or her duties effectively and efficiently. And so the way we understood members' deliberations is that members had agreed that Advocate Mqwebani had demonstrated incompetence in all of the various aspects that we had taken members through, and for those reasons, those issues looked at collectively show that there's a demonstrated and sustained lack of knowledge and ability of skill to perform. So members can just please confirm that we captured that correctly, that finding of incompetence in relation to all of these incidences that are described separately. Thank you, Chair.
Thank you, Mrs. Bryan. Honorable members, 1029 to 1031, your take. Honorable Ngola.
1029 to 1031 is in order, Chair. It's exactly, it reflects how we've agreed on as the committee.
Thank you, Honorable Ngola. Honorable Nkosi.
Agreed, Chairperson. Thanks.
Thank you. Supported. Honorable Dlakude.
Agreed, Chair.
Thank you. Honorable Tlape.
Agreed and supported, Chair.
Thank you. Honorable Siwela.
Agreed, Chair, through reflection.
Thank you. Any other member? None. Do we have any? Okay, before I ask for dissenting view, Honorable Lottridge.
Agreed, Chair.
Thank you. Do you have any dissenting views? None. I guess the hand is an old one, Honorable Ngosi, or is it a new one on the dissenting views?
Old one. Thank you, Chair.
Okay. Okay, thank you. That's agreed and supported. Back to you, Ms. Ibrahim.
So, Chairperson, the next section is the part B of the report, which is charge 4. It does require Chairperson to have to now remove one and load the new one on.
I indicated that we'll take a break when we conclude this, but before we take a break, I'm just checking my notes. Tsepo, can you go to paragraph 619, 619? I want to make sure I've taken notes as I went through to make sure that you were asking something to the committee in that paragraph. 619. And I realized so that after break you can fix that, Ms. Ibrahim. I think you were leaving Tsepo behind. She was a bit slow to catch up with you. Maybe she needs that break. Can we go to that paragraph before we conclude this section? Paragraph 619. Yes, thank you. I think the last sentence, it says, the committee must consider whether the further investigation thereof by Advocate Mkoban was necessary to get to the root of the free complaints that were before her. Ms. Ibrahim, so I just wanted to make sure so that we update this section. Is there anything else you still want the committee to consider here?
No, Chair. Perhaps the drafting needs to be changed, but it is considered in as the report goes on. So maybe it's just not clear. I'll make a note of that and just slightly amend the wording there.
That's it. I'm happy then. Thank you for that. That concludes this section, therefore, and we will take a 15-minute break, colleagues, and we will be back at 18 minutes past 12 to start the next section, part B. So far, I think we are on course in the manner we're doing it. So please keep up the good work. Don't log out. Just stretch break and whatever that you need to do. Thank you. We pause.
Recording stopped. Recording in progress.
Thank you. Welcome back, colleagues. It's now 18 minutes past 12. Hope you recharged during this short break. I'm going to ask Ms. Ibrahim to lead us into the next section, section part B of our report, doing the same exercise on the further charges. Over to you, Ms. Ibrahim.
Thank you, Chairperson. So, Chairperson, this is part B of the report, and it deals with charge 4, which members would have known was a misconduct slash and or incompetence charge. And this charge would have included FREDA, SARB, CHIDI, CR17, and the SARS unit matter. Chairperson, the first one, charge 10, that is what we had referred to as the HR charges, and we had gone into some detail on that during the deliberations, where members felt quite strongly in respect of certain persons that the facts established that there was harassment, alternatively intimidation, or victimization. So, for example, members found that with Mr. Samuels, they found that with Ms. Mokhaladi and Sekele. With Mr. Madiba, there were no findings. With Ms. Baloyi, there were all of those in alternate, with Mr. Kikana as well. But that charge, members will see that it has two elements to it. It also talks about charges against these persons being trumped up. And to some extent, the evidence establishes that charges were not trumped up against certain people. So, for example, in respect of Mr. Samuels, the assault did occur. So the report notes that the assault happened. It's not for this committee to consider the merits of that assault and what happened between him and Mr. Siabi, and to accept one version of the actual conduct of what had transpired there over somebody else's version. So the committee didn't seek to do that at all. And likewise with Ms. Mokhaladi and Ms. Sekele, the charges were not trumped up because there we know that they were charged pursuant to certain conduct in the CHIDI investigation. But what had happened is that Advocate Mqwebani, notwithstanding that the disciplinary hearing against them, the finding there was that they should be suspended for the period without pay. She then sought to dismiss them, which they challenged in the courts. So, Chair, we went into some detail over there trying to capture all of that. But the conclusion, and this is what needs to now be discussed with the committee, Chair, is the conclusion there that I've put in from a legal perspective, having applied the definition of misconduct in the rules, and just to remind members, the definition of misconduct as per the removal rules is the intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of public office. And as we said, the threshold is quite high to make such a finding. So whilst I have done my best to capture members' very strong sentiments on these HR issues and what members felt these people had gone through, we were of the view that it does not rise to misconduct for purposes of the rules. And therefore, as the report is currently drafted, it says that the committee does not make any finding of misconduct in respect of charge 10. But what we have done, as I've indicated, Chair, is to indicate that the committee appreciates this evidence that has come through from these various persons, and it's that not rising to misconduct is not done in a manner where the subjective experiences of those persons are questioned. My concern is with a legal argument, but the committee can apply its mind to the way in which we've captured that.
Thank you, Ms. Ibrahim, for that presentation. I now invite honorable members to interact and to make interventions. Honorable Nkosi.
On this issue, I remember in the deliberations, I was particularly vocal on this issue. I, however, agree with the legal service and that, however, we think, and subjectively so, the incidents of whatever do not rise to the threshold of misconduct. And I've just relooked, okay, I've relooked at the 8 memoir, and I agree with 83 Chair, that we must uphold it.
Okay, thank you. Honorable Lagude.
Honorable Chair, I agree with Honorable Nkosi. This is a true reflection of our deliberations as a committee. Thank you. I agree with it.
Supported. Thank you. Any other member? Honorable Maneli.
No, it's a great Chair. It's like Honorable Nkosi would have said, we spend a lot of time on this. We also tried to persuade each other as members not to go that route. So the reflection is through Honorable Chair. It's agreed to.
Thank you. Supported, agreed. Honorable Nwala.
It's supported, Chair.
Thank you. Honorable Siwela.
Agreed, Chair, and supported. Thank you.
Agreed. Any other member? Is there any dissenting view on 83 being the decision of the committee? None. We proceed. Thank you. Back to you, Ms. Ibrahim.
Chairperson, I just wanted to mention, though, that we did make it clear in the report that the committee is not saying that an HR-related issue can never rise to misconduct for purposes of the rules and have the effect of warranting a removal from office of a Chapter 9 head or functionary. It may be that the misconduct in respect of an HR issue is so serious that it could easily rise to misconduct. But for purposes of this, the committee, of course, heard evidence that counted the experiences of some of these people who said that they didn't experience the public protector to be a person as described by some of the witness. And also people spoke of her hard work and the fact that she was a hard taskmaster, etc., etc. So I just want to make it clear that it's not an agreement with, if I had understood the PP's representations correctly from the beginning, that this charge almost has no basis because you could never ever have made a finding. That was not the case. And notwithstanding that the independent panel did not make a prima facie finding here, this committee, of course, had the benefit of hearing from witnesses and sourcing additional evidence. So it might very easily have found differently, had the facts pointed differently. Chair, moving on.
Thank you for that. Thank you for that differentiation based on evidence, of course. Please proceed.
Chair, moving to paragraph 11.1. This was a charge of misconduct and or incompetence in relation to the management of internal capacity and resources. And Chair, I'm just going to ask you to go down to the conclusion. Chair, this charge, members will recall, dealt with the way in which management staff, investigators and outreach officers, how those resources were dealt with. And there's some overlap here, Chair, with paragraph 11.2, which is where the financial issues come in. So during the deliberations, when members spoke on staff and investigators and outreach, there was often reference to the fact that clearly there was monies that was being spent on the increase in litigation costs and so on. So that is what came out of deliberations. The committee strongly felt that there was definitely an unhealthy working environment, that resources were poorly managed, But again, on the evidence that was available, Chair, we are of the view that it doesn't rise to misconduct. And we deal with the financial issues and the decisions in terms of the litigation and so on as a completely separate matter. The issue with charge 4, Chair, is that there is much overlap in the way in which the charges are drafted. Some members would have seen that when they read through the report, and in fact 11.3 and 11.4 we sought to deal with together. So whilst members may have raised something in deliberations under 11.1, they'll find that it does actually then find application later on in 11.2. But it was our view, Chair, that for purposes of 11.1, that it does not rise to misconduct or incompetence.
Thank you. Your attention is drawn on 171, honorable members. Let me hear your take. Honorable Maneli.
Thank you, Chair. I would want to persuade the committee to agree to that point, as explained, that there is a separation of matters, and when we get to the finances as a separate matter from HR, it's something we'd be able to look at. So I agree, Chair, and persuade the committee. Thank you.
Persuaded and agree. Any other member? Honorable Lothrit.
Agree.
Thank you. Honorable Siwela.
Agreed, Chair.
Thank you. Any other member? None.
Agreed, Chair. Thank you.
Thank you, Honorable Dlagude. Is there any dissenting view? No dissenting view. We proceed. Over to you, Ms. Ibrahim.
Thank you, Chair. Chair, paragraph 11.2 was misconduct or incompetence by failing in an intentionally or grossly negligent manner to prevent fruitless and wasteful or unauthorized public expenditure. Chair, the first thing to note with this charge is that there's also some overflow here to paragraph 11.3, because the committee would know that we dealt with the appointment of certain persons and the use of certain resources that impacted impartiality and independence, but also came at a cost. So, for example, the appointment of Mr. Paul Ngubeni, the appointment of Kim Heller, and the work that they did for the PPSA, just by way of example. So there is that overlap which we've tried to capture. The first thing, Chair, is the use of the word unauthorized expenditure in this charge didn't find application, in fact, to the PPSA at all, because it's only departments that can incur unauthorized expenditure. Perhaps the motion had meant to say irregular expenditure, but we had agreed that we are not going to call Ms. Mazzoni or any other person to explain the motion, and that the motion will be treated as it is in front of us. So the wording here was unauthorized. It does not find application, and so it has not been dealt with. What we did deal with in quite some detail, Chair, was the issue of fruitless and wasteful expenditure, what the definition of fruitless and wasteful expenditure is, and whether the public protector then was negligent and she could reasonably have avoided some of these costs. And there's quite a bit of detail there in describing clean audits. And I think Advocate Bauer had taken the committee through it during deliberations to say that a clean audit doesn't necessarily mean that there's no fruitless and wasteful expenditure. Clean audits are based on samples, and there's certain things that auditors would not ordinarily pick up because they wouldn't even look at it. If you had requested a legal opinion and you paid for the legal opinion, It's not an auditor's job to check whether the legal opinion was necessary or the legal opinion served its purpose by way of example. So Chair, this goes into quite a bit of detail, but Chair, you can skip straight, I think, to the conclusion to make things easier, the summary. And members will forgive me that the numbering has come out as, yeah, it's gone a little bit funny, Chair, but we'll fix those things. But the finding there was that Advocate Mkhwebane has failed in a grossly negligent manner to prevent fruitless and wasteful expenditure by ignoring basic legal principles expected from an incumbent public protector in finalizing reports and then pursuing litigation endlessly and needlessly. So again, Chair, this is why I'm saying there's some tie back to the use of resources, the management resources and staff and so on. Advocate Mkhwebane's committed misconduct in utilizing resources to obtain legal advice and commencing litigation for personal gain, and in so doing committed misconduct by failing intentionally to prevent fruitless and wasteful public expenditure and legal costs. So this would, for example, be where we've had evidence on the securing of a legal opinion on crowdfunding, for example. Then Advocate Mkhwebane has committed misconduct in the performance of her duties by failing in a grossly negligent manner to prevent fruitless and wasteful public expenditure and legal costs by litigating recklessly, as demonstrated above. And we would have set out all of that in some detail. So if the committee is in agreement that the evidence that's been provided in terms of legal costs, what was spent, and given Advocate Mkhwebane's advice that the reason for the increase in legal expenditure is owing to the Nkandla report that made the remedial actions of the public protector binding, that had to be weighed against what the actual expenditure was and why was this expenditure being incurred. And the committee had deliberated at some length, but the conclusion that we reached there, Chair, is that it is misconduct.
Thank you, Ms. Ibrahim. Honorable members, 281 to 283, your contributions. Honorable Milam.
Thank you, Chairperson. Chairperson, I agree with the conclusions and I agree that they're an accurate reflection of our discussion. However, I want to draw attention to paragraph 283, the third line, where it says there was a failure to establish appropriate cooperative governance. I'm not sure if that's meant to be cooperative governance or corporate governance. Thank you, Chair.
Thank you. I want to ask Ms. Ibrahim to clarify that or fix it.
Chairperson, that's meant to be corporate governance, and it was something that was raised by Honorable Sukas during the deliberations.
Okay.
Thank you. We'll make that correction.
That's attended. Thank you, Honorable Milam. Honorable Nkosi.
Thank you, Chair. I agree with the conclusions. I think the paragraphs now has confused me, but in my notes on the summary, I think on paragraph 274, it says a clean audit does not mean fruitless and wasted had not occurred. But I think even in not oral, but as she was explaining the charges, she does say that does not necessarily mean. Instead of being emphatic that it doesn't mean, I think we should say that does not necessarily mean.
Okay. Okay.
Yeah.
Thank you for
there it is. Thanks, Chair.
You got that, Ms. Ibrahim?
Yes, Chair.
Thank you, Honorable Lagude.
Thank you very much, Honorable Chairperson. I agree with the conclusion and the amendments thereof. Thank you, Chair.
Thank you, Honorable Lagude. Honorable Mananiso.
Thank you, Chairperson. I'm covered. I'm adopting with amendments, therefore. Thank you.
You agreed with the amendments as well, Honorable Siwela.
I'm in agreement, Chair, with the conclusion as well as the amendment. Thank you.
Thank you. Any other members? Do we have any dissenting view? You
No,
will drop hands, Honorable Nkosi and Honorable Mananiso, unless it's new hands. Any dissenting views?
There is no
Chair. None. We proceed. Mr. Ngola, you're busy defending the dissenting views. Over to you, Ms. Ibrahim.
Thank you, Chairperson. Chair, we've dealt with 11.3 and 11.4 in the motion together, and 11.3 was a charge of failing intentionally or in a grossly negligent manner to conduct her investigations and or make her decisions in a manner that ensures the independent and impartial conduct of investigations. And we know that those are standards that must be followed by a public protector. And then 11.4, which ties in with that by deliberately seeking to avoid making findings against or directing remedial action in respect of certain public officials while deliberately seeking to reach conclusions of unlawful conduct and imposing far-reaching disciplinary measures and remedial action in respect of other officials, even where such conclusions and or measures and or remedial action manifestly had no basis in law or in fact. So, Chair, what was included as part of the evidence in charge 4, as I indicated, was all of the evidence that had already served before in charges 1, 2, and 3. But these aspects would have already been dealt with under there to a large extent, so it wasn't repeated in this section. However, the 2 additional matters that do come up in this section that the committee will be very familiar with is CR17 and the SARS unit, because we heard evidence at length, and in fact, we've heard the PP's oral evidence on those 2 matters also. So, Chair, what we did in the section of the report is deal with 11.3 and 11.4 together, and deal with firstly the CR17 matter, showing where there would be incompetence and misconduct there, and then doing the same in relation of the SARS unit matter. So I think SARS unit is first, Chair, or is it CR17? It's CR17. But the CR17. Yeah, so just prior to that section, Chair, we did a summary of the appointments of Mr. Niembi, who was appointed as the special advisor, and then the services of Mr. Paul Ngubeni, and we summarized all of that as a background to some of what follows in this section of the report. On CR17, Chair, I'm not going to take the committee through that in too much detail, but misconduct there came in respect of the issue of money laundering, that she questioned the bona fides of the president, and what we did ultimately is really rely on the Concord judgment, because the committee was in agreement on the evidence that was provided to the committee, that those findings of misconduct have been established here in terms of CR17. And then in terms of CR17, there were also aspects of incompetence in relation to the EMIR code. And over there, we also deal with the application of the EMIR code in the SARS, in the Gordhan matter, where it was also wrongly interpreted, where there was a complaint that Mr. Gordhan had misled Parliament, and similarly in CR17, where the president was alleged to have misled Parliament. So there we show that it's incompetence because of the wrong use or wrong version of the code. Chair, we've found in, for example, in the SARS unit, or rather not in SARS, on the Gordhan matter. Sorry, Chair, my notes are a little bit confusing because these 2 charges are together. Rather, on the CR17 matter, that the instruction to Parliament, for example, to take action against the President in terms of our own code of ethical conduct, would have shown incompetence because the president wouldn't have been subjected to that code. He's not a member of the House, by way of example. But there is quite a bit of detail in this section of the report, Chair, which is why it forms part of this Part B of the report, because of the amount of evidence that was led on these. And so members were in agreement with all of the findings and the factual findings that were made during deliberations and the conclusions that we then reached. Chair, maybe if you just want to go directly to the conclusions. So yeah, Chair, this is the Constitutional Court judgment in CR 17. I think you might have gone too far. Yeah, so Chair, we deal with also the attacks on Judge Potterill. There's quite a few elements in these charges. But yeah, as you can see from this conclusion, Advocate Mkhwebane contends that her decision to investigate was never influenced by the desire to target a certain individual, in particular the president. And she also argued that given that she had already been mulcted with a cost order, she should not be punished twice for the same offence, given the double jeopardy rule. But in fact, even though I think it was Advocate Mpofu that had said that she was mulcted with a cost order, she wasn't, because no personal costs were granted against her in her personal capacity. Then Advocate Mkhwebane had made serious findings against the president in the CR 17 report, and as I said, she impugned his bona fides in material respects, and in fact called him a liar under oath. That was the effect of it. And she found that the president had misled Parliament, that he had failed to disclose the donations to the CR 17 campaign, and that her investigation had supported a prima facie suspicion of money laundering. And the committee will be very familiar with the incorrect use of legislation in respect thereof. And then we go on to summarize what the Constitutional Court said in its CR 17 judgment, which doesn't need to be repeated here. The committee has already heard it in some detail. Yeah, so that's on that one. And you can move to SARS unit. Okay, so Chair, we provide the background on you can slow down the Chair, we provide the background on that investigation, go through in some level of detail on the reliance of all of those different reports, the Sikikane panel, what happened with the Sunday Times and the retraction, the KPMG reports, the SARS memo that the PP had placed reliance on that had gone to Minister Trevor Manuel at the time. And if you can just skip to the findings of the committee. Chair, you must forgive me because my counting in the Roman numerals is not that good, but after it says lawfulness and the SARS memo, the next one over there. And so, Chair, we summarize the findings of the committee as per the deliberations. What was in possession of the PP. I'm not going to read it all out because we have gone through it already. Chair, you can move down. Okay, if we go here, 778.1, the majority view was that the investigation of the SARS unit matter was not impartial, open-minded, or independent, and it was conducted in an incompetent manner. And the evidence pointed to a predetermined outcome, and also that the investigation was flawed. And we did capture the minority view there, which was from the Al Jama party during deliberations, Chair, that they were of the view that it didn't warrant her removal from office, and that she had relied on legal opinions from some of the best advocates in the country. But if the committee is in agreement with the way in which we've captured the fact that overall the committee finds that there is misconduct in Advocate Mkhwebane's failure to conduct an independent, impartial, and open-minded investigation, as well as incompetence in that she misinterpreted the law and found that the complaints were unsubstantiated, to the extent that she relied on discredited opinions and unreliable evidence for her findings and ignored information and retractions which showed that the evidence in question was unreliable and the opinions wrong in law. That was also a further act of misconduct. Chair, I think this paragraph might need some cleaning up because it's not reading very well. But the question before the committee is whether the committee agrees that in CR 70, in the SARS unit matter, there is both misconduct and incompetence for the reasons that we had set out.
Okay, thank you, Ms. Ibrahim. Bit of detail and navigating a lot of things there. Honorable members, back to you. I invite you to make your interventions. Honorable Nkosi.
Yeah, Chair. In respect of CR 17, I agree that the report reflects what we discussed, that there is misconduct. Also, in respect of the SARS unit matter, I agree that the committee found that there is misconduct on the side of the PP. Thanks.
Thank you, Honorable Nkosi. Honorable Maneli.
Thank you, Honorable Chair. I also stand to agree what has been presented. And I want Chair, for purposes of record, again, also indicate that also the part in F, which was not really presented as such for us to comment, because it links to the two, and the comparison that has been made with the other charges leading to that F. That's also agreed, Chair. Thank you.
Thank you, Honorable Maneli. Honorable Suela.
Thanks, Chairperson. I'm in agreement with the report. Thank you.
Thank you, Honorable Suela. Any other member? None. Is there any dissenting views? Any dissenting views? None. Thank you. We'll proceed. Back to you, Ms. Ibrahim.
Chairperson, maybe it would be easier if we just go directly to the summary of the findings.
Sure.
Chairperson, paragraph 1084. And
okay.
And the misconduct, Advocate Mkhwebane is found to have committed misconduct or demonstrated incompetence in performing her investigation and making decisions reflecting a lack of independence and impartiality, and deliberately seeking to reach conclusions of unlawful conduct and imposing far-reaching remedial action without basis in law or fact. And this is to do with the SARS unit matter. And the committee, in light of the aforegoing, conclude that charges 11.3 and 11.4 are substantiated to the extent that it reflects extraordinary steps here to impugn both the President and Minister Gordhan in a matter that reflects a lack of independence and impartiality and which do not meet the standards expected of a public protector. Chair, there we have captured, as I said, the view of Al-Jama that neither CR17 or SARS rise to misconduct or incompetence. Chair, there were two other matters that were also included that the committee didn't hear too much of evidence on. The one was the SARS subpoena matter, and the other one was the GEMS matter. But before I go there, Chair, can I just get confirmation? Am I correct that the committee is in agreement? Because when members spoke now, they spoke of misconduct in SARS unit and CR17, but it's misconduct and incompetence, both are dealt with. It might just be an oversight.
No, you're right. Let's just reconfirm that. Thank you. Members, I see, I don't know, it's old hands, Honorable Nkosi and Maneli.
No, Chair, I confirm as it stands in the report.
Thank you. Honorable Maneli?
No, Chair, confirmed, and that's the reason I also brought back F before, because there it was clearer also about both being applicable. Thank you.
Yeah, thank you. Honorable Dlagude?
In agreement, Chair.
Agreed.
Thank
Any other member? Honorable
Suela
Suela.
agreed.
Thank
I
you.
agree, Chair. Thank you.
Is that a new hand, Honorable Ngosi? Or gadgets?
No. Gadgets.
Thank you. Any dissenting views? None. We'll proceed. Honorable Ngola.
It must be registered, Chair, that there is no dissenting view. Thank you.
Thank you. I've registered that, Honorable Ngola. Thank you for that, for assisting the chair. Over to you, Ms. Ibrahim.
Thank you, Chair. Just to move to the SARS subpoena matter, this is also known as the Zuma tax record matter. Chair, in that matter, there was a dispute between the Public Protector and SARS regarding whether, in terms of the Tax Administration Act, SARS was legally obliged to release confidential tax information of individuals. So that act says that they can't release the private tax records, and the PP sought to obtain such records, and litigation ensued as a result thereof. And the High Court eventually ruled that the Public Protector did not have the power to subpoena personal information from SARS, and they ordered costs against her in a personal capacity. But there was then an appeal on the matter, which was dismissed on the merits. But the Constitutional Court did overturn the personal costs order. The PPSA then would have had to pay the costs. And in this matter, Chair, members will recall that when Mr. Samuels gave evidence on reckless litigation, Mr. Samuels had said that it's important that in some cases that there is litigation, that reports are reviewed, or where there's a legal principle that requires clarity, that the Public Protector must seek that clarity. And Chair, we contend that this would have been one of those examples as to whether the power of the Public Protector to subpoena documents would include the power to subpoena the tax records of an individual, because until this point, that question wasn't clear. So we don't believe that could rise to either misconduct or incompetence in seeking that clarity.
Okay. Thank you. Honorable members, your take on that summary? Let me hear you. Do you agree?
Agreed.
Honorable Nkosi agrees. Thank you. Any other member? Honorable
Suela
Suela.
agreed. Agreed.
Voted. Any other member? None.
Agreed, Chair.
In order, Chair.
You.
In order.
Thank you. Is there any dissenting view? None. We'll proceed. Back to you, Ms. Ibrahim.
Chair, the next matter is the GEMS matter. And this matter, members won't see it listed in the motion as such because it formed part of the additional evidence that was provided to the independent panel. The rules provide that the independent panel may get additional information, and this was submitted as part of that. Chair, I'm not going to go through the substance of this matter because it was covered during deliberations, except to say that in light of the fact that the committee has not heard any evidence on this matter, the committee obviously can't substantiate the complaint or the charge in respect hereof, and therefore there's no finding made in respect of GEMS. Okay, so Chairperson, moving to the next section of the report, that would be a very brief summary of the findings and recommendations of the committee. Of course, we know the findings. The finding is that the PP has misconducted herself and demonstrated incompetence, as we have now agreed to, based on what was contained in the draft report and for the reasons contained therein. What the committee needs to do, though, Chair, is to deliberate on the question of removal. At this point, Chair, I want to just make two comments. One, a Public Protector Chapter 9 functionary, as I said, can be removed on the basis of any finding, whether it be misconduct or incompetence or incapacity. In our case, we've got misconduct and incompetence. It is not necessary that there needs to be findings in respect of both, and that there needs to be findings in respect of every charge and subcharge that rise to misconduct or incompetence. So the committee may find that merely based on one particular aspect of the charges, if I use Vrede misconduct as an example, that Vrede misconduct alone is sufficient to warrant a recommendation of removal. On the other hand, the committee may have found misconduct in all of those matters, in all of the charges, even incompetence, but still not be of the view that it warrants removal. What the committee needs to do now is to deliberate on this question specifically of removal and what it intends advising the NA in terms of a recommendation in respect thereof.
Okay.
Just to remind us, sorry, Chair, the second thing to remind members is that the Constitution says you may remove on a finding. The NA does not have to remove on a finding of misconduct and or incompetence. So the committee can similarly also take that into consideration.
All right. Thank you for that support and advice, Ms. Ibrahim. Maybe before I get into there, I just want to conclude the gems so that I hear the members on gems, and then we then get into this. So your comments on the GEMS part as presented, honorable members, before we get into deliberating on the actual removal and non-removal. Your brief comments on GEMS, you did not comment on that. Do you agree or you don't agree with what has been placed? Honorable Maneli?
Thanks, Chair. I'm not sure if the capturing takes care of the point I want to raise.
Yeah.
Because on this matter, it was firstly to note that, of course, there is a court decision in this regard. However, the committee did not hear any evidence. Now, the point being made here, Chair, is that we are not ignoring that the matter would have served the court and there's a decision in that regard, whilst we have not heard the evidence. So I thought I should raise it now, whether in the way it's captured, that is taken care of. Thanks, Chair.
Okay. Thank you, Honorable Maneli, for that contribution. Any other member on the GEMS? Honorable Dlagode?
Honorable Chair, thank you very much. I do agree with Honorable Maneli. Indeed, we didn't hear any evidence as the committee, except for what the court pronounced on it. So we didn't make any conclusion in this regard. I agree with what is put here. Thanks, Chair.
Thank you, Honorable Dlagode. Any other member? None. Do I have any different or dissenting view on the GEMS matter?
Chair, I'll rephrase it to capture the sentiments of members just to make it clearer. But my understanding is that members are in agreement that we have not we've not reached any findings in respect thereof.
Yes. Yes, that is the point. Thank you for that. You can do that cleanup and refine that in line with the members' contributions. Honorable Suela?
No, Chair, it's a mistake, but I wanted to support the two speakers. Thank you.
All right, thank you. Thank you. Now we conclude, we're done with the GEMS matter, which would have been the last one. And therefore, Ms. Ibrahim has then drawn our attention as this committee to an important task of this committee. You know, having traveled this entire journey and today having considered this draft report and made the kind of decisions that we have made on each of the charges or sub-charges, whether in this area to exonerate, whether in this area to sustain what is misconduct or incompetence. And therefore the question that I'm inviting members to deliberate on, to respond to, is what advice, having done this work, having just gone through this in the manner we did, based on the evidence that we have, and in certain areas with no evidence, and the kind of decision we have taken, what are you advising the National Assembly to do in relation to the actual task of this committee? The removal or no removal? I invite members to deliberate and throw their ideas and contributions. Content advisors, as well as the legal advisor, are here, will record those issues, and that will form part of our conclusion and recommendations. Thank you. Do I have any first taker? Honorable Lawthrit.
Thank you, Chairperson. Yes, I think, as you say, we have gone through a long process, I believe a very thorough process, and we have examined all the charges that were brought. We listened to the evidence. We have deliberated on that. Today we are dealing with our report, and based on our findings as a committee, in terms of misconduct, incompetence, I do think that at this point, the committee should go forward and propose and recommend to the National Assembly that the public protector be removed from office. Thank you.
Thank you, Honorable Lawthrit. I now invite the next hand, if I have. You suggest that Honorable Maneli, that the public protector be removed from the office based on our evidence, our findings, and the work that we have done. Honorable Maneli.
No, thank you, Chair. In relation to the findings and the report as it has been presented, the matters of misconduct and incompetence are sustained, which would have been the basis for a removal. Therefore, that removal is recommended. And I'm using the recommended, Chair, because we are still also going to give the public protector an opportunity to comment on our report and elect to comment or not comment, in which case our report will then stand, Chair. So I just thought I should just emphasize that point so that we are open to consideration if there are comments that are to be made. Thank you.
Thank you, Honorable Maneli. Honorable Nkosi.
Thanks, Chair. I agree with the previous speakers that after having considered all evidence and presented to the committee, we recommend, we do find that there's misconduct and incompetence, and recommend removal on that basis. I just want to add that we exonerate in relation to all those issues that are in the report, that they exonerate them. And that the report be forwarded to her for comment before it is brought back to the committee for finalization.
Thank you, Honorable Nkosi. Honorable Tlakude.
Thank you very much, Honorable Chairperson. With the evidence before the committee with regard to misconduct and incompetence, Honorable Chair, I will want to join my colleagues that we recommend for the removal with a view that we are still going to hear from the PP's reaction to this draft report. So that's my take, Honorable Chair. That recommendation will mean that based on her reaction to our report, then there is space or there is a chance for reconsidering based on what she would have put on her response to our report. Thank you, Chair.
Thank you, Honorable Tlakude, Honorable Siwela.
Chairperson, let me take this opportunity and join my colleagues that the evidence before us mandate us to arrive to that particular decision of removal. So I'm in support. Thank you, Chair.
Thank you, Honorable Siwela. Honorable Ngola.
Thanks, Chair. Chair, we would have indicated in our first meeting of the committee, even before evidence was led, that even if we find in one charge evidence of misconduct and incompetence, that would mean that we'll recommend a removal. I think Ms. Abrahams is echoing the same sentiments the committee has agreed on in its first meeting. So given the evidence that has been led before the committee, it suggests that in many of the charges contained in the motion, the public protector would have misconducted herself and would have displayed high levels of incompetence. Therefore, I do join my colleagues in recommending a removal. We recommend that the public protector be removed. Of course, Chair, will give consideration after having sent the draft report to the public protector if she elects to make representations in terms of the draft report. And of course, I agree with Honorable Maneli that even at the point where she elects not to make any representation in terms of the contents of our draft report, that would mean that she would be in agreement with the draft report and will table as it is in the National Assembly. So we agree that we must recommend to the National Assembly that Advocate Sisiwe Mkhwebane, the public protector of South Africa, be removed from office. Thank you very much. In line with Section 194 of the Constitution. Thank you.
Thank you, Honorable Ngola. Honorable Sukas.
Thank you, Chair. Chair, in light of the evidence before the committee and the conclusions that has been drawn by this committee, I support what was made by all my colleagues as well, that after the consideration of what will be put before us after this report, that this committee moves for the removal. I support that. Thank you.
Thank you, Honorable Sukas. Honorable Mautwe.
Thank you, Chair. Chair, it is clear that the report is, in our view, is premature, and it demonstrates the determination of you as the chair and the entire committee to move with the speed to impeach the public protector, regardless of the litany of procedural mishaps committed by the committee since inception.
The hurried nature in which this report has been prepared, Chair, lays credence to the view held by the public protector that this is a frivolous political process meant to punish a person who is non-compliant with the dominant narrative which seeks to hold up the current head of state as a saint. Chair, apart from the many procedural own goals by yourself as the chair and the committee, the most important issue at the moment is that the PP has not had legal representation in the committee since the termination of the funding for her legal fees by the acting PP. And this dates back to as early as March this year. The acting PP's belated offering of 4 million has been mired in controversy, which has not allowed the legal protector space to have legal representation, the public protector. So the acting PP indicated that the PP must appoint her legal reps herself and manage the additional 4 million that the office of the PP made available as she wishes. I mean, this was unheard of, Chair, and it placed the PP in a very precarious position because she's here to account for her performance as the public protector and not as a private individual. Secondly, Chair, this committee railroaded the PP to have the state attorney as the attorneys of record. This was done despite the PP having raised concerns about the conflict of interest of the state attorney. This was disregarded by this very same committee, further exposing the PP to a state-sanctioned witch hunt, whose figurehead has always been the chairperson. When the PP finally managed to appoint Chani attorneys, the committee refused to give them time to acquaint themselves with the record. So on what basis were these attorneys going to brief counsel if they themselves did not have an opportunity to study the record and get to know the cases? You said earlier that the PP should have briefed the counsel. It's not correct, Chair. It is the attorney that goes through the records and briefs counsel, of course, on the instruction of the PP. Now, Chair, Rule 129 AD requires that this committee must conduct its proceedings in a reasonable and procedurally fair manner. You can never claim that your conduct was reasonable or fair in the manner you have handled this. From the initial directives, Chair, that you issued yourself, right up to the end, the process has been grossly unfair to the PP. I mean, you can cite instances, Chair, but we don't want to spend the whole day here. So the findings in the report that the PP demonstrated incompetence in relation to the charges against her were therefore predetermined. This is the mandate that the chairperson and the evidence leaders were given, and these findings were made without affording the PP with their constitutionally enshrined rights to legal reps. So in conclusion, Chair, if the PP has to be impeached, that must be thorough and through a procedurally fair process. We say, let us give the legal reps of the PP time to get familiar with the record so that they can brief counsel properly. Why are we rushing to conclude this process? Because it will come back to bite this very same institution if we do so. The fact that the report mentions that the process will be moot after the term of this PP expires in October is proof enough that this process is no longer about justice, but about punishing an individual. Parliament can't be reduced to a tool for punishing individuals. Chair, let us give the legal reps of the PP the 1 month they need to get familiar with the record so that they can brief counsel. That's our position. Anything else that being suggested by the committee members, we reject it. And we reserve our rights to take this report on review because it looks like we're going to be beaten by numbers here. It's not factual. It's just numbers. A lot of people are saying this, and therefore we should take it even though we feel that is unfair to the individual. So if you continue in the manner that you're continuing, you are going to leave us with no option as the EFF but to take this matter on review. Thank you, Chair.
Thank you, Honorable Mautwe. I now recognize Honorable Mailam.
Thank you, Chairperson. Chairperson, let me start by saying, firstly, that I agree with the recommendation and findings as presented by various other members of this committee. I also find it utterly bizarre that Honorable Maotwe should make the statements that she did given that she did not object to a single one of the findings on any of the charges that were presented. In other words, by not objecting
Chair,
to
on a
those
point of
charges,
order. Chair, on a point of order.
Yes, just a pause, Honorable Mailam. The pause, Honorable Maute, what's the point of order?
Why is this guy addressing me? Why is he addressing me? Does he have no point to speak? I spoke here. I never cited any of the people that spoke before me. So he comes here and he speaks about me because he's got nothing to say. The husband of the complainant. Firstly, he should have not been allowed to sit in this meeting. Chair, that's what makes this process even more flaws. So everybody who speaks here speaks through you, Chair. I don't think you appointed anyone to be a spokesperson to respond. Normally what you do at the end of the discussion and deliberations, you give your own views and attempt to respond to some of us. So why is he speaking about me?
Thank you, Honorable Mautwe. Your point of order, firstly, is not sustained because this is a matter of debate and contribution that you have now. Secondly, you know that members here are honorable members. We don't have a guy in this committee. And so I would want you to restrain and not to repeat that. And so I'm not.
Yeah, but he behaved like a boy. We're going to call him a boy because that's exactly how he behaves, Chair. There's nothing honorable about mayhem here. Nothing.
Honorable Mautwe, I did not.
No, Chair, you're not going to do that to me. Don't do that.
Honorable Mautwe,
I've been listening here painfully throughout the day on all the nonsense that they've been saying, including him. I never said a word because I knew that the time was going to come for me to speak. Now he opens his big pink mouth and mentions me. I'm not going to allow that. This guy must withdraw, speaking about me.
Honorable Mautwe, I've asked you to step down, refrain from what you're doing, not sustaining your point of order. You continue to make unwarranted, unparliamentary comments, even when I'm asking you as a chair not to do that.
Because you're unfair yourself, Chair. No, you are unfair.
Honorable Mautwe, you are now disrespecting me as a presiding officer.
Protect me. That's all I'm asking you.
I'm not going to protect you. I'm going to have to enforce the rules on you. I'm not going to do that.
Chair, as long as you tell him not to mention me, I will keep quiet. I will keep my peace.
I did not invite you to speak.
No, but Chair, you are unfair. Everybody must speak through you. That is what I'm requesting you to do.
I did not even note you to speak, Honorable Mautwe. I want you to stop.
Yeah, but tell him to speak through you, not through me. If he talks about me, he's inviting me to respond.
Can you firstly let IT just mute her for now? Thank you. And I'm not going to repeat this. If she does, she'll repeat what she's doing. That point of order is not sustained. It's a frivolous point of order. And Honorable Mailam, I want to give you the platform.
Thank you, Chair. Chairperson, as I was saying, I find it actually bizarre that we could go through all the charges and not a single objection was raised at any point by Honorable Maotwe or anyone for that matter to the findings that we had made throughout this report.
On a point of order.
And then
on a point of order.
Honorable Mautwe, what is the point of order?
Can you call this person to stop calling my name, please?
Sorry,
Honorable He must make his point. He must make his point and leave me alone. I'm at peace here. I'm not bothering anyone. Can I not be bothered?
You're not going to repeat what you're doing, Honorable Mautwe. I've already
I'm saying to you, it's in the
rules. I've made a ruling.
We speak through you. Don't act like the part of the DA here. Please, you're not. This is not a meeting of the DA.
Please mute her again.
This is not that meeting.
Please mute her again.
If you
for the last time, please mute her again for the last time.
Chair, if you continue speaking about me.
Honorable Mailam, please continue.
When I may don't talk about me when.
Chairperson.
Go ahead, Honorable Mailam.
Thank you. Thank you, Chair. So as I was saying, it's actually bizarre that there's no objection to the merits of the matter. But when we come to the recommendation, at that point, Honorable Maotwe then decides that the matter is now up for debate. And I find that bizarre because as a committee, we have gone through this.
I'm not a DA member, and I don't take instructions from you. What bizarre? Did you have a caucus of how we must?
Go ahead, Honorable Milam.
We've gone through this. We've gone through this evidence very carefully.
What protects you is the color of your skin, nothing else. Nothing. You're not making any point. Nothing.
Continue to mute, Honorable Minister Ngoma.
Thank you, Chair. We've gone through this evidence very carefully, very thoroughly over an extended period of time, and the committee has made its findings and its recommendations based on evidence. To now say that the process that we have undertaken or the steps that we have followed have been a witch hunt, I think is absolutely unsubstantiated. So that's my first point. My second is this, Chair. During the course of this hearing, there were threats made on your person by Advocate Mpofu. And I believe that this committee has a duty in its recommendations to firstly refer those threats to the Legal Practices Council for investigation into conduct unbecoming by Advocate Mpofu. And secondly, to take the necessary action, which I believe is criminal action, in terms of the Powers and Privileges Act, where a member of parliament is threatened in the course of his or her duties. So, Chair, I would ask that those be included in the recommendations of this committee. Thank you, Chair.
Thank you, Honorable Milam. I now recognize the last two hands with second bites.
Chair.
It will be Honorable Mautwe, followed
Yes.
by Honorable Maneli as your second bite to contribute. Over to you, Honorable Mautwe.
Thank you, Chair. Chair, I understand when you say it's our point for debate, but it's definitely the point where we now talk to each other. Honorable Milam was extremely out of order, and I don't understand why you didn't call him. Throughout the whole process, Chair, we've always been talking through you. There's been so many things that I said that you don't agree with. Now, for him to come here and tell me that I've been quiet the whole day, how can I participate in a process that I'm saying is flawed? It's procedurally unfair. I said that in the morning. Where was he? He was not listening. He just comes here because we're at the end and we're not in agreement with him. And therefore, I should have spoken for each and every point. We deliberately kept quiet, Chair, because we said from the beginning of this meeting today that the PP does not have a legal rep. So why must we participate in this process? I'm registering our objection to the report now because I want it in record. And Chair, you should have called Milam to order because he's mayhem like that. And we for as long as he talks, he calls my name. I've got the right to defend myself and I've got the right to speak and protect in the absence of your protection as the chairperson. So everything that we've said stays, and we don't agree with him saying that we must take Advocate Mpofu. He must go and study law himself and stop hiding behind being a husband of a matriculant. He must go to school and practice and be an attorney and be an advocate, and then he can come and challenge all those things. For now, he's just an honorable member who's not even honorable of anything. We reject this report, Chair.
Thank you, Honorable Mautwe. Your points have been noted. Honorable Maneli.
Thank you, Honorable Chair. I just want to start, Chair, by indicating as we adopt the report that there would have been an agreed approach to the report of going through the point by point. And you've ran it fairly, Chair, that even if there would have been quite an overwhelming number of members who would have commented in the affirmation of what is presented, that an opportunity for a dissenting view would be asked and be recorded, and that there's been record as South Africans are following these deliberations, that such did not exist. And it therefore doesn't make any discussion that comes at the end to nullify the process that would have been followed. So I just thought I should raise that point as the first point. Second point, Chair, is that our understanding remains that this report is a draft report of the committee, which is still a subject in terms of Audi for the public protector to also elect to comment, which in that case the committee should have an open mind to consider what would come from the public protector. In the same vein, where the public protector elects not to contest what is put in the report, it will be regarded as such, and that the committee is able to adopt the report finally and take it to the National Assembly as such. I'm raising this, Chair, so that we place it on record that there is a process that we have followed, and that process has been agreed by members in a committee meeting, which is this committee that has been proceeding, not anywhere else. And I want to restate the point that, Chair, from the beginning, we would have agreed that we do not carry mandates from elsewhere, except considering facts that will be before us, sift them, and make a determination. And it is against this background that in some of the matters, even if they could have been found to be in existence by another fora, whether it's a panel or what, and that as a committee will come to a point that you exonerate the public protector on those matters. That's about fairness, open-minded committee that looks at facts that are presented before. And therefore, on those that would have agreed, it's also, Chair, informed not only by what was already there, but it's on evidence led before the committee. And by that evidence, I mean all the witnesses, including the public protector herself, putting up her own report, both in writing and partially orally presenting before this committee. And surely for those South Africans who equally would be like members, like ourselves, who have attended every committee meeting and processed every information that is put before the committee, would probably come to the same conclusion that the matters before us are just about facts, and the decisions that we're making are about facts without external influences and so on. And these could be tested as such, as these facts can be manufactured. And I want to say, Chair, even if we may try and spend time to politicize the matter, but at this point, given facts before us, even that politicization is running short of changing the facts that are before us. And we are using the facts, unfortunately, in order to arrive at a conclusion. And this conclusion, therefore, is informed by that. So I just thought that should be clearly on record. And surely South Africans, as I said, they've been following the deliberations. They know that even other matters that are said now may have been challenged before. They have been in courts and they were cleared. This includes the route for this committee to proceed. This is a matter that has been cleared. And once it was cleared and we proceeded, it meant that slogans and everything else went out of the window and that we needed to proceed as mandated by the National Assembly. I think, Chair.
Thank you, Honorable Maneli, for your second bite and contribution. Honorable Ngozi.
No, Chair, just a few points. Firstly is that I believe that all members in the committee brought an open mind and were very objective for the past year or so in pre-processes, including in the internal process, in the process of the committee itself. That's the first point, and therefore that in our consideration of both the procedures that were followed and the substance of the issues that were raised, we have always been very reasonable, open-minded, and have applied in all respects and objectively so fairness and deference to, or rather add on the question of fairness all the time. Secondly, that it is not true that this committee denied the public protector legal representation. If you recall, Chair, that at one point the proceedings were adjourned to ensure that she gets legal representation, and it was an effort of this committee to avail the opportunity for the PP to be legally represented. And we never proceeded an inch without affording her that legal representation. Of course, the choice is an election is on her side once such legal representation was availed or opportunity to obtain such was availed. So up to today, the understanding is that the PP had always had legal representation done, and that it is her election to utilize it that has denied her effectively representation in the committee. Lastly, Chair, I think that we should reiterate the view that we have found misconduct, incompetence on the side of the PP and recommend removal. Thanks, Chair.
Thank you, Honorable Nkosi. Do I have any other member? Honorable Sukas.
Yes, thank you, Chair. Chair, I think the parts that I just want to emphasize is the part that the process that we are in right now is a process that has been mandated by the National Assembly, and it forms part of the oversight function of Parliament. Much has been done to ensure that there were fairness, and we have traversed this point again this morning and throughout the whole process. When I became part, and I make it personal, of this committee, I came into this committee with no preset mind whatsoever. We have laboriously listened to evidence. We've listened to the public protector as well. It cannot be made that this process be, again, at this point, this late point, be smeared to the point of a political witch hunt or a political process with a predetermined outcome. The many hours of listening to people speaking or witnesses coming before the committee cannot be reduced to that. The millions of rands that has been spent on the process to ensure a fair process cannot be reduced to that as well. And I think it is important for us as members to reflect on the oaths that we have sworn to the Constitution and to function within our duty as parliamentarians. Throughout this process, I think, has been an education for every single member to again go back and see what our duties are. For me, it was that. So I think it is important for us just to be very cognizant of what the expectations are of the people who has elected every single party to represent them as South Africans in the National Assembly, and to consider the impact of the lack of fairness to those who has been impacted, say, for instance, in the Vrede Dairy matter, the poorest of the poor. So we cannot reduce this merely to an individual. We need to look at it within the constitutional duty of the National Assembly and the service to which we have sworn ourselves. Thank you.
Thank you, Honorable Sukas. I now recognize Honorable Hendricks.
Thank you, Honorable Chair. I would like to put it on the record that we appreciate your fairness throughout these proceedings, and also the generosity of all members who allowed everyone to add their voice, and that is indeed appreciated. However, as you know, Honorable Chair, this is a motion of the Democratic Alliance. Although 60 members of the ANC abstained from voting on this process when it came before Parliament, Al-Jamaa voted against the motion. We have expressed our views, and to just put it on the record that we don't support the removal of the public protector. And we feel that there are some political parties who have asked their members to follow the party line. So we don't agree with you that it has been a very impartial process. But having said that, we don't support the removal of the public protector and feel that she must serve her full term of office. Thank you very much.
Thank you, Honorable Hendricks. And now recognize Honorable Dana.
Thank you, Chairperson. Chairperson, I'll reiterate what I've said before during these proceedings, and that is that there are all mechanisms and remedies to the public protector's disposal if she does not agree with this process, anything that happened during this process, or anything that's written in the report or the outcome of this entire process. So I agree that the public protector must be removed. I agree with the report. And as I said, it can be taken on review. Honourable Mahotwe has indicated that the EFF is considering taking it on review, and they're welcome. It can be taken on review, but I agree with the process. I think we've been fair, and that's my 2 cents. Thank you, Chair.
Thank you, Honorable Dana. I now recognize Honorable Tlakude.
Thank you very much, Honorable Chairperson. Let me state this, Honorable Chair, that we are a committee established by the rules of the National Assembly. And on the establishment of that committee, we were tasked to embark on a fact-finding mission. Based on that, we had witnesses that came before the committee. They gave us their evidence. They were asked questions by both members of parliament, the PP's legal reps, and also the evidence leaders. So the PP herself took a stand to give us, she gave us her statement and also took the stand. Unfortunately, she couldn't proceed with giving us oral evidence. We worked based on, we relied on her statements that she deposited to this committee. And based on those facts, Honorable Chair, that is why we are where we are now. Let me also indicate that I agree with my colleagues, Honorable Chair, because as a committee, I think we've been very fair when it comes to this process. You even as a chairperson, went out of your way to ensure that the issue of the funding is attended to, even though it was not the responsibility of this committee to deal with those issues. With regard to legal representation, Honorable Chair, yes, we had that so many times that she has a right to legal representation, of which we agree with. But the process, there was a time when it was abused. You also indicated today, Honorable Chair, that the Chane attorneys were given enough time, enough chance to brief the attorneys. Firstly, Mr. Chane was admitted in hospital, he recovered, came back. They were given a full month to brief the senior counsel. And also, let's remind ourselves, the senior counsel and also the Chane attorneys are the PP's choice of legal reps. And another opportunity which they should have used in this process, of which I believe, sitting here, that they failed to utilize that, was that the senior counsel has been there from the start up until now. So they should have utilized that opportunity, because looking into all this, there was not a chance where, there was not a time where the senior counsel missed this process. So, Honorable Chair, I want to reject the notion that as members of other parties, we were given a mandate to remove the PP. There was no such mandate. I'm speaking now on behalf of the ANC. There was no such mandate. The conclusions and findings that we came to are based on what was presented before us as members of the committee. And also that there is so much number of members of the ANC who abstained from voting. Voting for what? Because we have not come to that as of now. So, Honorable Chair, this process, according to my understanding, was a fair process. We went out of our way to be more than fair. We are still, after this meeting, going to give the PP a last out, of which we are saying, after that, we are going to sit as this committee to reconsider our decisions based on her reaction to the draft report. After that, the report will be taken to the National Assembly. It is the National Assembly that will decide on what to do with the report. Ours is to recommend. So let's stop this thing of accusing or of being accused as if we came here besizingela siphethe ichiwo. Angithi ngisho njalo. So
Yes.
this Honorable Chair, I'm saying, is really uncalled for those members to accuse us of this. We are all members of Parliament, and also, I don't think we would deliberately misuse taxpayers' money for something that we don't believe in. So, Honorable Chair, that's my presentation. Thanks.
Thank you, Honorable Lagude, Honorable Suela, and then I go to Honorable Nola.
Chairperson, I'm a little bit disturbed. I don't know what is it that we are doing now. Because as the committee, we have gone through all processes correctly so. And on the issue of fairness, more special from your side and ourselves, we have been patient. And I want to support Honorable Dakode on the issue of mandate. We don't have any mandate which we were carrying here. We're trying to be objective, Chairperson. We listened to all people who came and gave evidence. Our recommendation or recommendations is based on the deliberation made throughout. So I want to really emphasize the issue of mandate, that we don't have any mandate here. Otherwise, we would not sit for 1 year. Our main concern, Chair, the delay tactics which were happening, we were quite aware about it. the issue of abusing taxpayers' money was also a problem to us. So coming here to be accused that we are carrying a particular mandate is wrong. Two, we are arriving to this point today because of the evidence we received along the lines. Again, Chair, you have been accused, and yourself, you have been highly accused that you are supposed to leave the chairperson position, and of which we did not agree, majority of us, because there was no reason for you to do that. So today where we are, we haven't yet concluded, as other honorable members have stated, we're still waiting for our PP to respond, and then it's then that we will come back and look at her responses, and then we'll take the matter to the National Assembly. So the issue of accusing us here that we're carrying a particular mandate is wrong. And again, this process, according to me, it was fair. We've been patient enough. So, but we can't allow this process to delay any longer because we're dealing with taxpayers' money. So my submission, Chair, is that we are fair, we have been fair, and will continue to do so. So the recommendations as they stand, we are tabling them, we're adopting them as the committee, so that we move forward. And then after the responses by the PP, we're going to table the matter into the House. And is the House which is going to take a particular decision. But let people stop accusing us in this matter. Thank you, Chairperson.
Thank you, Honorable Suela. Honorable Ngola, you the last one hand that I've noted.
Thank you, Chair. Chair, I think we must correct one thing here, that it is quite not correct that PPSA withdrew funding. On record, a letter addressed to the committee and to the public protector, it is clear that they say in the content of the letter that the funds that were allocated for the basis of the inquiry have depleted. They have even exceeded the limit they have set. So it was a depletion of funds, not a withdrawal of funding. There is a difference between the two. Chair, there is an issue about legal representation. No part of how this committee had dealt with matters properly is that every correspondence is shared amongst committee members. And it is on record, Chair, that Chane attorneys, after the withdrawal of Sianego, did indicate that they are on record attorneys of the public protector. They have since went missing. The report that the committee got was that Mr. Chane got sick. This committee halted its proceedings because the report was that there is no one in the law firm that would best represent the aspirations of the public protector. If you don't call that fairness, therefore we need to have a redetermination of what fairness means. After that, there was an indication that Mr. Chan has recovered and now back on the queue. There is a correspondence to the committee to that effect. And therefore we have resumed, Chair. We have given Chan attorneys two opportunities. The first is to brief the senior counsel of the public protector. The correspondences that have been exchanged between Chane attorneys and the committee do indicate that Chane attorneys failed to brief the senior counsel. The second opportunity, Chair, was to go and read the record. They were given that opportunity. They requested more time. You know, Chair, you are given time, you don't start working. Because it would have been different if they were given time, they started working and could not finish on the time we have given them. Then it would have made sense for the committee to extend the time they were given. But what is reported in the committee is that they have not even accessed the Dropbox to go and read the record. It means they've been sitting doing nothing, playing on minor delay tactics, and the committee and parliament can't afford to go beyond what we're instructed to do. Chair, it is not true that it's us, these committee members, that are rushing the process. The process is rushed by the rules of the National Assembly. The National Assembly rules instruct us that we must conduct this process within a reasonable fair time. We would have, Chair, to gauge our fairness, we would have initially set this inquiry for 35 days. But because circumstances on the ground dictated that we extended for more than a year. Because we wanted to undergo a seamless and a fair process. So what we must not do and we must refuse to do is to want to play politics with this process. And in my own view and in my own school of thought, a conscious revolutionary will be on the side of the people. A conscious revolutionary will stand in protection of the institution that belongs to the people, not the person who's occupying that institution. A conscious revolutionary, Chair, would actually stand with those whose rights were infringed. The beneficiaries of the Fred Dairy Farm, who until now have not benefited anything. The motive forces of our own revolution, who have been robbed their right to farm in Free State. A conscious revolutionary would actually stand with those people, not those whom sit in the higher echelons of power. Thank you very much, Chair.
Thank you, Honorable Mola, the last speaker to make a contribution. Let me thank all of you, honorable members, in terms of your contributions and discussions on this item, focusing on the recommendation on removal. Before I make the summary and indicate the way forward, maybe it's proper to just walk back a bit and said, as we started today's meeting, I would have indicated that amongst other things, consistent with our commitment to do this work from day one, we would have spent 18 hours of our time on a Friday and Sunday as members of this committee, ably supported by our team of the content team, the legal advisor, and evidence leaders as directed. And that we spend those 18 hours designing our own report as the committee, and would have been very patient going through charge by charge and subcharge by subcharge. Having done that, and would have noted contributions that were made during that time, which we're able to carry through and demonstrate and reflect today, as Ms. Ibrahim was able to do. And so today, from 11 o'clock, we spent valuable time as this committee, taken through the summary of our own deliberations and decisions in considering this draft report. For each charge and each subcharge, we were able to allow deliberations for each and every member who wanted to do so, as Honorable Maneli says, including giving space for any member who had a different view or a dissenting view. And for each charge and the sub-charge that we went through, I would have allowed for members on record to indicate what their decision is. And members did so. And would have supported each other, agreed, interrogated where they were not clear. And we did that step by step, both Part A and Part B of this comprehensive report, draft report that has been put together. And I would have invited for factual dissenting on each particular item, whether it's a main charge or the sub-charge. And I must just indicate that from 11 o'clock until we concluded that exercise, I've certainly, as a chair, recorded no one who has dissented on each main charge, on each sub-charge that we went through. I would have allowed that, and I would have repeated twice regularly. The draft report does, however, recognize minority views that would have been entered into during the period of the 28th of July and 30th of July, where the good party in certain areas would have indicated a different understanding and a different phrasing of a particular matter. The report has reflected, and today that would have been repeated. We're reminded of that. Al-Jamaa, through Mr. Hendricks, the report reflected on the issues that you would have entered on the 30th of July, that Sunday, where Al-Jamaa and Mr. Hendricks repeated that today in saying that they do not support the removal of the public protector. And in those deliberations, Al-Jamaa would have made their points in each of those charges where they were present in terms of where they stand on a particular issue. And so we've gone through that exercise. It's on record. It was happening transparently for everybody that followed this from 10 o'clock when we started, and from 11 o'clock when we started the actual going through the report section by section, led by Ms. Ibrahim. Everybody would have recorded that, so that's on the record. And having concluded that, we then, colleagues, got into the summary of what is it that we want to recommend to the National Assembly. And that's what I want to summarize now. Majority of members that would have spoken are of the view that we must recommend to the National Assembly, based on the work that we've done, very concrete evidence with facts and this long hours of work that we have put into this as part of this journey, that in adopting this draft report, the committee is recommending that the suspended public protector, Busisiwe Mkhwebane, be removed from office in line with Section 194 of the removal of the heads of Chapter 9 institution, based on the kind of work that we've done, informed by this evidence, and the detailed work that we've done. And that is so because the committee was able to sustain and establish evidence that sustains the misconduct and incompetence charges, whether this is CX, this is Friede, CR17, the Gordon matters, and so you go, as well as issues of incompetence. In our deliberations, we're very clear that there are areas where the committee was of the view that much as there was a very strong feeling by members of the committee when we deliberated on those 18 hours, that the issues that we feel strong about do not escalate or make us to conclude in certain areas that there is misconduct and incompetence. This committee deliberated on that and made those kind of conclusions, and therefore has been very firm in saying in these areas we do not find that the evidence that we have establishes that she is incompetent or establishes that she has committed misconduct. This is on record, has been very clear. And so our decision that we're taking, members are of the firm view that that is subject also to hearing, as we're going to now give from latest tomorrow, going to give the last audit to the public protector, the suspended public protector, to comment on the adopted draft report of this committee, and will await what comments she makes or comments she does not make into the report. Thereafter, we will be proceeding as this committee to therefore table our report to the National Assembly in line with what would have happened in the 7 days plus or so, or 10 days that would have given the suspended public protector to have a final audit on the matter. That's the majority of the decision of members. I, however, need to note very strong views that have been raised by the economic freedom fighters through their member, Honorable Bautwe, who's of the view that the adoption of the report that we're making is premature, that we're involved in a frivolous exercise. It's a rushed report, even if this is after a year and a half we're at this work. That in her view, and as the EFF, they reserve the right to take the report that will conclude to a review. And so that has to be recorded. We note that as a matter that cannot be wished away. It was raised here, it was articulated, and I would invite Honorable Mautwe to even share some of the manner she would have phrased this so that we're able to include it in our report. Additionally, Honorable Hendricks repeated the points he would have made as part of the deliberations on the 30th of July. Firstly, that as far as Al-Jamaa is concerned, they do not support the removal of the public protector. Of course, I must say this because it looks good. It feels good for the chair that he appreciates that he does not have a biased chair. He has a fair chair that's accepted. And so, honorable members, that's the summary of the work. I'm not going to take anything away from the contribution of members. Members have assisted me to make a much briefer summary by taking and responding to many of those issues and clarifying to everybody out there about the journey that we have traveled, because this is our journey. It is us that know this particular journey. Everything is on record. Even as we speak and as I conclude this summary, the suspended public protector has not been denied any legal representation. She has elected not to utilize what this committee has offered to her. And therefore, the withdrawal of that and non-action on the availability of the legal support is not the same as not having it. It's important that that point is made. So I want to thank you, honorable members, to say that is how we want to summarize this. And before I proceed to us adopting our minutes, Ms. Ibrahim, anything having led to this report that you want to get clarity on or you want to comment on?
No, thank you, Chair. Chair, we'll proceed to draft the recommendation to the Assembly and include that in the report, and then also to do some of the final cleaning up that I had alluded to. Obviously, that won't involve any substantive changes. It was things like numbering, and if there's any spelling mistakes or anything else that we may pick up when we do a final read through now, when we consolidate. Thank you.
Thank you, Ms. Ibrahim. Thank you, honorable members. That concludes that section, that part of our meeting. We now get into the last part of our meeting, which is us finalizing and adopting all of our minutes that were outstanding. And I'm going to ask Mr. Ngoma to lead us into that. And you only get into minutes if you are present. So just to remind you so that we don't contaminate our records. If you're not present at meeting, don't move for the adoption or even support it. Thank you. Mr. Ngoma?
Chair, like that meeting of the 28th, we're very much busy with the 10th anniversary.
I knew.
No, it was in our program.
I want it on record that it was the day before, the big rally in South Africa, you know.
No, thank you, Mr. Ngoma.
Thank you, Chair. Good afternoon and good afternoon to honorable members. Chairperson, the first set of minutes to table the minutes of the 28th of March 2023.
Okay, you take us through so that we go through who was present, any corrections, page by page, page one.
Chair, just sorry about that, Chair. It should actually be the minutes of the 23rd of March, where the committee, sorry, Chair, so many documents here opened.
Yeah, you removed it. We don't see it.
I'm sure it's there now, Chair.
Yeah.
The minutes of the 23rd of March, tabling of correspondence, consideration of revised committee program, and adoption of outstanding minutes. It was a almost full house, Chair, with a number of apologies. And yeah.
Okay. Any corrections, honorable members? Is that the last page? Okay. Remember, these minutes were sent to all of us. Do I have a mover?
I move for adoption, Chair. I was present in the meeting.
I second.
Honorable moves. Honorable Siwela seconds. Minutes duly adopted. Thank you. That's for the 23rd of March. Next set of minutes.
Thank you, Chair. The next set of minutes then is the 28th of March. It was a Tuesday, and Advocate Mkwebana appearing before the committee. Very short minutes, Chair, because all of this is contained in the report that the committee just adopted.
All right, thank you.
I move for adoption. I was present.
Honorable being present moves for adoption. Do I have any seconder?
Yes, I second.
Honorable Ngola seconds. Minutes therefore adopted.
Ngola is seconding, Chair, also noting the stand-up committee Honorable Maude is talking about.
Okay, thank you. We'll go to the next set of minutes.
The person, the next set of minutes is Wednesday, the 29th of March.
Let's go to the next set of minutes.
The 29th of March, Chair, also the appearance of the PP before the committee, Chair. Also just very short minutes. Thanks, Chair.
Thank you. Any mover for adoption?
So the move for the adoption?
Honorable Suele moves for adoption. Any seconder?
Carter seconds, Chair.
Honorable Klape seconds. Minutes therefore duly adopted. Let's move to the next set of minutes.
Mr. Chairperson, the next set of minutes will be the minutes of 30th of March, a continuation of the appearance of Advocate Mkhwebane before the committee. Yes, sir.
I move for adoption of the minutes, Chair.
Honorable Judy Hermans, not Hermans, moves for the adoption. Any seconder?
A second, Chair.
Honorable Ngosi seconds. Minutes duly adopted. Next set of minutes, Mr. Ngoma.
The last set for March would be the minutes of the 31st of March, also with the PP appearing before the committee. And Chair, it's Hermans, Chair.
Thank you very much.
Again is read. Do I have a mover for the adoption of the minutes?
I move, Chair.
Honorable Matlaule moves. Any seconder?
Second, Chair.
Honorable Ngosi supports. Minutes duly adopted. Next sets of minutes.
Next set of minutes, Chair, the minutes of the 4th of April. Yes, Chair, wherein the evidence leaders made presentations to the committee.
Okay.
Chairperson, safe to say that the day was meant to be a hearing. Yeah.
Thank you. Do I have a mover for the adoption of the minutes?
I move,
Chairperson. Thank you, Chair. Move for the adoption of the minutes.
Honorable Ngosi moves. Any seconder?
I second, Chair.
Honorable Dlagude supports. Minutes duly adopted. Thank you. We proceed to the next set of minutes.
I'm just trying to find them quickly, Chair. Apologies. As indicated, there's a lot that is opened on this laptop. Okay, there we go. Chairperson, those are the minutes of Wednesday, the 5th of April. Also presentation by evidence leaders.
Thank you. Any corrections? Do I have a mover for the adoption of the minutes?
I move, Chairperson, for the adoption.
Honorable Dlagude moves. Any seconder?
I second, Chair.
Honorable Mkhwebane seconds. Minutes therefore duly adopted. Thank you. Can we proceed to the next set of minutes?
Next set of minutes, Chair, the minutes of Friday, the 14th of April. Also presentations by evidence leaders, Chair.
Okay, let's go through that page by page. Any corrections? None. Do I have a mover for the adoption of the minutes? Those who are present?
I move, Honorable Chair, for the adoption.
Honorable Dlagude moves. Any seconder?
I second, Chair.
Honorable Mkhwebane supports. The minutes therefore duly adopted. Thank you. We proceed to the next set of minutes, Mr. Ngoma.
Next set of minutes, Chairperson, Tuesday, the 18th of April. You, Chair.
Thank you. With no corrections, do I have a mover for the adoption of the minutes?
I move, Chair, that the minutes be adopted.
Thank you. Honorable Hermans moves. Any seconder?
I second, Honorable Chairperson.
Honorable Lagude supports. Minutes therefore duly adopted. Can we move to the next set of minutes?
Thank you, Chair. The next set of minutes would be the minutes of Monday, the 8th of May. Should also note that on this day, the hearing had to be postponed.
Thank you. Do I have a mover for the adoption of the minutes? Those who are present.
I move, Honorable Chair, for the adoption of the minutes.
Honorable Lagude moves. Any seconder?
I second, Chair.
Honorable Hermans supports. Minutes duly adopted. Let's move to the next set of minutes, Mr. Ngoma.
Next set of minutes, Chair, is Wednesday, 17 May. Also, here, Chair, advocate was expected to appear before the committee. And this meeting was postponed to allow PPSA to finalize the issue of legal representation, the hearing in actual fact, not the meeting, Chair. Thank you, Chair.
Thank you. No corrections. Is there a mover for the adoption of the minutes?
I move for the adoption of the minutes, Chair.
Honorable Seke moves for the adoption of the minutes. Any seconder?
I second, Honorable Chair. Thank you.
Honorable Lagude seconds. Minutes duly adopted. Can we move to the next set of minutes, Mr. Ngoma?
Next set of minutes, Chairperson, is the second correspondence and the consideration and adoption of the committee revised program.
Thank you. Any corrections that you've picked up? Do I have a mover for the adoption of the report of the minutes?
I move for the adoption of the minutes, Honorable Chair.
Honorable Lagude on point moves. Any seconder?
No one to check.
Honorable Kwalangola supports. Minutes duly adopted. We thank you, members. We move to the next set. Mr. Ngoma.
Set of minutes, Chair, the 7th of June. This was also meant to be a hearing, Chairperson.
Okay, let's go through and check who's present and what are the corrections. Go. Any corrections, members? None. Do I have a mover for the adoption of the minutes?
I move for the adoption, Honorable Chair.
Honorable Lagude moves. Honorable Tseke supports.
Second, yes.
Thank you. Minutes duly adopted. We move to the next set.
So the next set of minutes is the minutes of Friday, the 9th of June. Also, this date was supposed to be a hearing day.
No corrections. Do I have a mover for the adoption of the minutes?
I move, Chair.
Honorable Weber moves and Honorable Ngosi supports. Minutes duly adopted. Can we proceed to the next set, Mr. Ngoma?
Yes, Chair. The next set would be the 28th of July, coming up right away. Friday, the 28th of July, where we received a briefing from the chair on the application. and it was considered by the committee, and we also committee began with its drafting of the report.
Thank you. As Chair was present, that's the 28th of July, Friday. Any corrections? None. Do I have a mover for the adoption of the minutes?
I move for the adoption of the minutes, Chair.
Honorable Hermans moves. Any seconder?
I second, Chair.
Honorable Mashaule supports. Minutes duly adopted. Thank you. Proceed to the next set.
The last set of minutes is minutes of Sunday, 30th July, wherein the committee finalized the drafting of the report, of the draft report that it has just adopted now. Thank you, Chair.
Thank you. The 30th of July, that's Sunday. Do I have a mover for the adoption of the report?
Suele moves for the adoption
Minutes.
of the report.
Of the minutes, Honorable Suela moves. Any seconder?
I second,
Moved.
Honorable
Second.
Chair.
Honorable Tlagode supports. Minutes duly adopted. We're going to take today's minutes, Mr. Ngoma.
I don't have an issue with sharing today's minutes. They are ready. That's if members are ready to adopt them, Chairperson. As you can see.
The chairperson has not seen those minutes. They can't be adopted. So today you can leave those out.
just to show Chair, they are ready.
You can leave them out. The chair must apply his minds on the minutes and bring minutes here.
Wow.
Thank you, Chairperson.
Thank you. That's the end of the minutes. We only have got one set of minutes to adopt, which is today's minutes. Just to indicate members that with the conclusion of this meeting today, we're going to do the work to ensure that your work proceeds to the next step, as I would have indicated both in the letter to the suspended public protector and in this meeting that latest tomorrow we'll be sending this draft report to the suspended public protector for her comments, and will indicate the timelines given to that. We have indicated in the letter to her that it will be up to the 21st of August as an end date before we receive the report. Based on the receipt of that report, on what would have been the comments and so on, the committee will convene in order to send a final report to the NA. Would have indicated previously as well that you must be on the lookout for another day, a date that we're going to be planning. Just to remind you, we said we want to have a session where we deal specifically with what we call the reflections and lessons of our work. We do not want to mix that with the drafting of the report. And already members have started speaking about those issues. We are going to do that work so that we also compile that. Also, what would be outstanding, Ms. Ibrahim, would be the conclusion and with the recommendation that was done today. So you will indicate how much time you will be able to take that, but it's not different from what the report has. Ms. Ibrahim?
Thank you, Chair. As we always,
unless as I was going through the minutes, you were able to have captured that. Let me hear you.
That's what I wanted to say, Chair. As we always do when we're sitting in a committee, we always draft something in advance and then just put in the absolute necessary that we to Chepo, but members will just forgive me if there are any editorial things that need fixing. for me, what's most important is that I capture what Honorable Moutwe and Hendricks have said, and that's correct in the report.
Okay.
I ask you to put that up.
Just even though it has not gone through the chair, I will allow for that so that it's a committee product. They can deal with that. So please go ahead.
Thank you, Chair. So Chair, what we sought to do was to just bring the entire report together, because you can't have a conclusion that is just hanging. The content advisors certainly wouldn't have been happy with a product like that. And what we did was to talk a little bit in this conclusion about the Kada Asmal reports that members would obviously be very familiar with. And that was the report that was done on Chapter 9 institutions, and checking to see whether those institutions were fit for purpose and doing what they were meant to do as it was envisaged when the Constitution was drafted. And that's almost 17 years ago to the day that report was tabled in the NA. And we've just captured some of what that report noted. It's a good reminder for the committee as to what the role of these Chapter 9 institutions are and what the drafters had in mind. And of course, Chair, a lot of this would have been traversed with Mr. Ibrahim when he set out the background to the establishment of the public protector and so on. Chair, you can move to paragraph 4, please. Chair, yeah, we've just indicated that the importance of the Office of the Public Protector can't be gainsaid, and that was very clear from the evidence that this committee's heard. The committee heard from ordinary citizens affected by the work of the Public Protector, both positively and negatively so, as well as the staff of the PPSA. And the task that the committee was given was now to assess whether Advocate Mqwebane, who's been appointed to support, protect and promote our democracy, has failed to meet the standard of conduct expected of her, or has demonstrated incompetence in the performance of her functions, and that this was an unenviable and challenging task. At least it was for committee staff, Chair. And we've also said that the committee has remained cognizant of the fact that the importance and the independence of the public protector is paramount. And the PPSA faces many challenges, and those are some of the things that the committee would have to consider when it considers other lessons learned and the way forward, if I can put it that way. There were challenges in the PPSA Act that we've heard about. There were challenges about resources and so on, which the committee can apply its mind to in this follow-up session that you spoke of, Chair. Chair, we note that the report obviously makes serious adverse findings of misconduct against the public protector in a range of investigations, reports, and a handling of subsequent litigation. That there's also evidence giving rise to several grounds of misconduct, not just one. And in relation to the charge of incompetence, that the committee is satisfied that the various instances of incompetence, when you cumulatively look at it together, then show incompetence as defined in the rules. And I just put in some examples there quickly, Chair, but I mean, we can always beef that up. But I've also made a note here in 11, Chair, because it's come up several times during the proceedings of the committee, that we note the 3 clean audits, which was historical because it's the first time in the history of the PPSA that these clean audits have been achieved. That there's been significant inroads into the backlog of cases at the PPSA, a situation which the current PP inherited and she was committed to improving. That there was appreciation of her hard work, and also that she had significantly increased the number of reports that were issued. But at the end of the day, Chair, the legal issue is such that those matters regardless of how laudable they are, that is not what the committee was tasked with considering. The committee's task was to consider the veracity of the charges as it was in the motion and to make findings in respect thereof. So the consensus, Chair, there I've just captured that the committee has satisfied itself based on the evidence before it and the submissions it's received, that the PPS misconducted herself on multiple occasions and that this warrants removal. In terms of the minority view and abstentions, Chair, there weren't any abstentions in the technical sense. I've recorded that Al-Jamaa did not support the removal from office of the PP, citing that the process has not been impartial and she should be allowed to conclude her term in office. And then also in the report itself, Chair, members would have noticed that we've captured some of what Al-Jamaa had said when we deliberated on particular aspects. In terms of the EFF, and I can please, if I could, Chair, ask Honourable Moutway just to assist me to make sure that I've captured this correctly now. The EFF did not object to any findings of the committee during deliberations. However, it noted its very serious concerns about the fairness of the process, and to this extent stated that any adoption of a draft report would be premature, hence its choice not to engage in the deliberations. The EFF noted that the proceedings have been grossly unfair and procedurally flawed, conducted in a hurried nature, constituted a frivolous political process with a preconceived outcome, and is not fair in light of Advocate Mkhwebane not having legal representation since 31 March 2023. The conduct of the committee to continue with adoption of the draft report is therefore not reasonable and is grossly unfair to Advocate Mkhwebane. The EFF indicated further that it intends to review the report of the committee. So that, Chair, was me just trying to sum up how I understood Honourable Moutway's contribution. And then, Chair, lastly, I just recorded that whilst no parties had abstained from voting, there were a number of parties that were not present. I don't know if I've captured them all correctly, but I'll check that with the Secretariat when we adjourn. And the recommendation then of the committee is what's captured in bold, that the committee, having duly considered the motion, recommends that the National Assembly, based on the committee's findings of misconduct and incompetence, resolve to remove Advocate Mkhwebane from the Office of Public Protector as provided for in the Constitution. So, Chair, I still need to clean this up because obviously it's now been done very quickly. And as I indicated, I need most importantly that there's agreement on 14 and 15, and then generally from members on the rest.
Okay, thank you. Mr. Ngoma, any issues you want to correct on the attendance?
I think it will just be a matter of adding the Congress of the People, because even though the members never attended, they are listed on the register as of the committee. So it's just for us to just be to end was on the 16th.
Okay, that's fine. Thank you. Let me now come to members. Firstly, I want to do two things. If there are any general comments or corrections or issues that you want to point out. And then secondly, lastly, we'll do the mover and adoption of this draft report finally, so that it's done with, now that we have this working conclusion and recommendations. So I'll do it in that way. Any general comments, Honorable Hendricks?
Thank you, Honorable Chair. I know you did say that a special day to look at. However, I would like the committee to consider adding to the report that the 6 and 9 committees are normally informal committees, quick resolutions. We have now learned from deliberations that in the case of the public protector and the researcher and the lawyers made reference to the act as well, it looks like we are moving towards a specialist court that the public protector's office should no longer be a Section 9 committee because it is very onerous and it is like a...
Just reposition. We're not hearing you. Please come closer to the mic.
Can you hear me now, Honorable Chair?
No, we can't hear you. There's a problem there.
Let
Yes,
me...
now we can hear you. You are now muted. You are now muted.
Can you hear me now?
Yes, Honorable Hendricks, thank you.
Oh, thank you very much. I was just saying that, you know, you did say we're going to have a special day, but I feel it's important to note that an immediate lesson learned is that to be a member, to be a public protector is very onerous and doesn't meet the informality that we expect of Section 9 committees, and that maybe there must be consideration that the Office of the Public Protector be a specialist court in terms of the act that I can't remember what you call it, but that it should be a specialist court, and there's an act that provides for specialist courts. I say that, Honorable Chair, because as you know, we are busy appointing a new public protector, and I don't know if there's going to be time for this, but certainly, you know, we have to note that it's not easy to be a public protector because you have to cross your T's, dot your I's. Not that other Section 9 committees do that, but it certainly smacks of a specialist court. Thank you for this opportunity.
Thank you, Honorable Hendricks. We'll park that idea for that session and deal with it there. Thank you for bringing it up. Honorable Maneli. Honorable Maneli. Honorable Maneli. I think he seems to be frozen. I don't see any movement on his mic. In the meantime, is there any other member who wants to make a contribution on just the conclusion and recommendations before we go to the move and support action from what Ms. Ibrahim just lastly put up now? So are you then happy with the conclusion of our report and the recommendations? Honorable Dlagude?
Thank you very much, Honorable Chairperson. I think what Ms. Ibrahim have presented to us just now with regard to our deliberations and conclusion as of today's meeting, I fully agree with it. I don't think there's anything that needs to be added there. We are fine, Honorable Chair. It's what we discuss, and this is what we came up with. Thank you very much.
Thank you, Honorable Dlagude. Any other member? Honorable Suela?
Chairperson, thank you. I concur with the latter speaker. The conclusion and recommendations is what we have agreed upon. Thank you.
Okay, thank you, Honorable Suela. Any other member? Any dissenting view if there are no other members? No dissenting view. Can I now ask for a mover for the adoption of this entire draft report, now that it has a conclusion in it? Honorable Ngosi?
I so move, Chair, that the committee adopts this provisional report.
Thank you. Honorable Ngosi moves. Any second?
Honorable Swele, second.
Honorable Swela seconds. I have Honorable Mailam. You had your hand up.
No, Chair, thank you.
Okay. Thank you. Therefore, this draft report is duly adopted. And I have already indicated how it is going to proceed from here. There being no other matter that we need to attend to, honorable members.
Chair.
Honorable Mautu?
Yes, with the objection of the EFF.
Oh, sorry. I now recognize and note the objection of the EFF on the adoption of this report. Thank you, Honorable Mautu. That will be so noted and recorded. Thank you. With that, colleagues, I think that's where we get to the end of our meeting. The time now is 14:43. Would have started at 10 o'clock again on this Friday. I must just appreciate your commitment as members of this committee. We're not done yet with our work, but you have demonstrated consistently that you take serious what you have been asked to do by the National Assembly. Whilst we're still going to thank our team, our support team, and everybody else who's been part of this journey. For now, we want to say thank you for being interested, doing your part, especially the team that has worked tirelessly, bent the night, all long hours to produce the kind of work that we've adopted now. Thank you very much. We still want you to still polish this further and make it a good report, but want to thank you for now, and to thank everybody else who's been in this meeting, members of the public, for your consistency. We note your own comments. I get to be notified as a chair what you're saying, and we have just indicated now, especially to you as members of the public, that we're going to have a separate day when we deal with issues of reflections and lessons. And so you might want to share your thoughts around that. But thank you very much. Thank you, honorable members and colleagues. The meeting is adjourned. Thank you.
Recording stopped.
Thanks, Chair.
Thanks, Chairperson.
Long live